progress.
Good morning and welcome to this session of the virtual coaching classes organized by the Board of Studies of the Institute of Chartered Accountants of India. Today, we will be getting into, I suppose, quite an interesting topic. We'll be talking about the special courts, adjudication, the National Company Law Tribunal, and the National Company Law Appellate Tribunal. Before we go there, it is necessary for me to give you a broader introduction to the topic for the day. I might have mentioned it in an earlier session, maybe when I spoke about inspection and investigation, or maybe, I don't know, mostly in inspection and investigation. I would have shown you that a democratic country like India delegates the roles of the government. So the government of India, sort of a democratic government, supported by a constitution, for the people, of the people, by the people, operates in a very peculiar way. See, having said this, it's not as if monarchies or dictatorships operate differently, except that in a democratic country, the law is not given by the king or laid down by the dictator, but it is rather, shall we say, evolved, discussed, debated, deliberated, and finally, there is a body where the representatives of the people meet, and they, a majority of them, once they pass the legislation, it becomes a law. You might ask me, why are you giving all this nonsense, sir? We know all this. I know you know it, but now this law is made by the parliament, which is called the legislature. Right? There is one wing of the government. So the legislature or the act of parliament lays down the law. Right? Now that the law will possibly be, see, there are Ajar laws in this country in addition to the Companies Act. So every law has a goal, has a purpose, but finally the law wants to bring about some kind of an order in society. So the law lays down certain rules and regulations, and it says, and it tells the citizens, you have to do this, you have to do that, or you shouldn't do this, or if you have this problem, you can approach this body like that. Now, but then who will administer this law? The parliament cannot come on a daily basis and administer the law. That is where we have another wing called the executive. Now, the executive consists of the ministries. So each department, each subject has a ministry. So you have the Ministry of Law and Justice, you have the Ministry of Finance, you have the Ministry of, the Ministry of Finance is responsible for both collection of taxes and revenue and also for spending it, popularly known as the North Block in Delhi. Now the Ministry of Finance, of course your Ministry of Corporate Affairs, so on and so forth. There are so many ministries. Now each ministry has been given a certain subject to handle. Within that framework, any law that applies to that framework, that ministry will administer it. So the law is made in parliament, the law is administered by the various ministries, the executive, and finally, suppose, see, in a democratic country, why in a democratic country? Any body of men or people who have come together and want to be together need some kind of a, shall we say, remedial measure. In case the executive, the administrators exceed their powers, or they wish to, they have not gone in accordance with the spirit of the law or whatever, there should be some method by which the citizen can approach a higher authority and claim justice. So that is why we have the Ministry of Law and Justice, which is responsible for setting up courts, C-O-U-R-T-S, courts. So these courts are part of the judicial system. So they work together, right? Similarly, suppose a citizen has violated a law, or allegedly violated a law, then the executive needs to be able to punish him. Now the executive cannot punish, or the executive cannot pass the order for punishing a citizen. This is done only by the court. So all that the executive can do is adjudicate. They can, using the power vested in them in the law, they can prepare a case and present it to the court and say, this gentleman or lady has violated this particular section. Here is the section, here is the violation, here is the proof, punish him. Now, this is called prosecution. I repeat, this is called prosecution. This is not particular or peculiar to the Companies Act. Such provisions are there in every law that you will study. The Income Tax Act has it, the Companies Act, of course. Later on, when we see PMLA, the Prevention of Money Laundering Act, you will find it. FEMA has it. I'm sure you would have already understood that. The Foreign Exchange Management Act has it. Every law. See, a law without an adjudication process is meaningless, because the executive means the administrating mechanism, whatever it may be, whether a ministry or a department of that ministry or a commission or a special body set up for this purpose, like the Serious Fraud Investigation Authority, whatever it is, if they want to proceed against the citizen, they can't do it directly. There is the need for the intervention of the court. Arrest is not possible unless you are got a judicial warrant. So this is possibly one of the important, shall we say, landmarks of a democratic system, that any action by the executive which could be prejudicial to the citizen needs to be judicially reviewed. I know this sounds a little unnecessary, but not really. As you know, my usual methodology, provisions should not be mucked up blindly. Just because the institute material starts with one particular area, you start reading, you may not understand it. And I'm able to understand it from some of the questions that come to me on WhatsApp, and I feel that many students have not even understood the basics, but they are asking doubts at the higher level. See, they have not studied at a foundational level. They have not understood the basis, principle, but they are smart enough to ask questions at the higher level. Now, to give them the knowledge at the higher level, unfortunately, they need to be educated at the fundamental level, which is what I'm doing. So the court system in India was set up for the purpose of giving some sort of a protection to both the citizen as well as the executive. The courts are like the balance. See, the famous poet Thiruvalluvar in his Thirukural says, "Saman seidu seerthookum kol." Saman seidu seerthookum kol. The balance, which has to be straight. So the balance cannot tip. It's not supposed to move. It should be straight. So it should maintain the equality of both the plaintiff and the defendant. In this case, the prosecutor and the accused. So once you get into prosecution, the person against whom the punitive action, the penal action is being taken is called accused. I mean, nothing wrong in that, because so long as the case is not proved, so long as the crime or so long as the offense has not been proved by the government, he is not a convict. He is only an accused. Every fact is alleged unless proved. See, these are the beauties of the jurisprudence and the judicial system in this country. Now, having said this, there is already a beautiful judicial framework in this country, beginning with jurisdictional magistrates sitting at the district level. Some of them, there are hierarchies of these magistrates. You got the chief judicial magistrate, you got a judicial magistrate, first class, you got a judicial magistrate, second class, then you got a, executive magistrate, and then within them, again, some of them are called metropolitan magistrates, so on and so forth. Depending on if that guy is sitting in a city, a metropolitan city, he is called a metropolitan magistrate. So there's a whole network of judicial magistrates sitting all over the country who are jurisdictional. So any offense committed under any law within that jurisdiction needs to go to that judicial magistrate, right? Suppose you are not happy with the decision given by the judicial magistrate, or the executive magistrate, you went to the judicial magistrate on an appeal, and so on and so forth. And if you are not happy with the lower courts, as they are called, these bodies are called the lower courts, the district courts and the metropolitan magistrate courts are called lower courts. And if you're not happy with the decision of the lower court, you can go on appeal. You can go on appeal to the jurisdictional high court. So each state has one or more than one high court. See, it depends on the size of the states. The high court will sit in many places, wherever it is. For example, the Madras High Court, as it is still called, we don't call it the Chennai High Court, I don't know why, call it the Madras High Court. The Madras High Court has sittings in Madurai, Coimbatore, and other places also. Same, I'm sure the same. So it's similarly with Maharashtra, which is a pretty huge state, and or Uttar Pradesh, which is pretty huge. I'm sure the High Court sits in various places, and they hear the benches are there in important cities to hear appellate matters. That is, when the citizen is not happy with the decision of the lower courts, you can go to the High Court, and of course you can go on appeal from the High Court on specific issues of pure law. Only a question of law can survive and go to the Supreme Court, right? A question of law alone will go to the Supreme Court. The Supreme Court is the highest judicial authority in this country, where a full bench, there is 3 or more justices of the Supreme Court sit and pass a judgment. Possibly that is binding on everybody in this country. You can't argue after that, unless the Parliament decides to change the law. See, which is what happened in our Vodafone case, where the Supreme Court gave a decision on the Vodafone case, which is good. There's nothing wrong in that. But then the government of India, the Ministry of Finance, felt that there was a need to correct the law, and they amended the law, Section 9. They amended it retrospectively, and so they gave themselves the power to reopen assessments for 14 years and all. No, all I'm trying to say, somebody was asking me this question: what happens if there is a thing? See, which is the final authority? Technically, you have to see. Nobody can answer this question on a permanent basis, but on a case-to-case basis, I can say today what is the position. I can say, for example, there is a Supreme Court decision. The law has not been changed. Then the Supreme Court decision is final, right? There is a Madras High Court decision on that particular subject. The law is ambiguous, and that's why they have interpreted it. See, you already studied it in intermediate in interpretation. The courts will not get into case, they will not get into judgment when the act is clear and unambiguous. Only when it is ambiguous, they have the right to come in and say, hey, this is what, in our opinion, this is the meaning. No problem. Once the Madras High Court gives a decision, it is binding on all the lower courts and all the quasi-judicial bodies operating within the state of Tamil Nadu. But it may not be binding on my neighboring state of Karnataka. So the CIT appeal sitting in Karnataka can always say, look here, that's a Madras High Court decision. Show me a Karnataka High Court decision. It's binding on me. Otherwise, it's only persuasive. But if it's a Supreme Court decision, it is applicable to all. Now, this framework was set in place, obviously, as we all know, not by the Mughals or by the Mauryans, but by the British. So the British set up the system, and they were operating it for easily 150 years on our behalf. They were giving justice to our cases, which is why many of the case laws in company law and contract are from the pre-independence era, still applicable, still valid, including your Foss versus Arbotle, still valid. Now, the point I'm making here is, why then, if this framework is already in place, why then would we need special courts? Yes. Why then these special courts? Because the number of cases is so high, and courts are simply deluged with cases. And they are human. You see, even the judges sitting in the bench are human, and they have only so much. They have to be careful because, see, the principle of jurisprudence, given to us by the British, which they themselves borrowed from the Romans, they themselves learned from the Romans, is very clear. They said 5 guilty people can go free, but 1 innocent should not be punished. 5 guilty people can go free, but 1 innocent should not be punished. This is the golden thread of British jurisprudence, which is taken from Roman law. So, but then the British really gave meaning to it because they worked at it. Even though they were colonizing, even though the people they were ruling were merely subjects, they still maintained the dignity of a court and maintained the dignity of innocent until proved guilty. Okay, including patriots like Mahatma Gandhi, others were brought before a court and they were judged by the law then prevailing. Right? Maybe the law was wrong and maybe that's why we needed to become independent. But the British were administering the law as it was prevalent at that time and they said, hey, by this law, what you have done is the action is guilty and we punish you. I'm not justifying this. I am saying the judicial system was working well, but the number of cases and litigation ensured that your magistrate courts were deluged with cases. So when company law matters also go there, okay, when an offense under the Companies Act goes to the judicial magistrate or the executive magistrate or the metropolitan magistrate, he doesn't really have the time for it. He says, hey, remember, every case goes there. I'm not joking. Every case, check bouncing case, 138 goes there. Civil cases at the small causes go there. More importantly, all offences under the Indian Penal Code go there. Theft, prostitution, right? Drug trafficking, everything goes there before him jurisdictionally. So, how many cases can he see? And moreover, this gentleman has got a lot of specialization in the Indian Penal Code, the CPC, of course, the Civil Procedure Code, and the Criminal Procedure Code. He will be authority in that. He knows everything in that. But you ask him something in company law, maybe he may not be, I'm not saying he's not aware, but that may not be where he is. So, and this is true not only for company law, but for many things. So, the many other subjects also. So, the Government of India in 1979 enacted the Special Courts Act, which is a common law. And this Special Courts Act empowered the central government to establish special courts for speedy trial of certain offences. So they said, hey, you are a special law and you are coming under a special category. Maybe these magistrates don't have time to hear you. Okay, we will set up special courts, which would then hear only these matters. So remember, your special courts set up under the Companies Act 2013 have their genesis or source in the Special Courts Act 1979, by which the central government has been empowered to establish an adequate number of courts to be called special courts. It shall consist of a judge from High Court who is nominated by the Chief Justice, in whose jurisdiction the special court is established with the concurrence of the Chief Justice of India. But you will notice that in the Companies Act, it's slightly different. We'll come to that. But the essence is that central government has the power to establish special courts. What is the purpose of a special court? For providing speedy trial of offences under this act. Okay, except under section 452. 452 deals with punishment for wrongful withholding of property of a company. 452 will be taught in miscellaneous topics. Now, so the point here is, if what happens in 452 is the court cannot simply pass an order for levying a penalty or imprisoning the person. So imprisonment. So it goes beyond that. They may also have to pass an order for restitution of property, etc., which is normally not a special court subject, which is why they say let's keep 452 alone separately, because the court may have to go into elaborate factual and documentary evidence to establish whether there is a wrongful withholding, etc., etc. Okay. So that's why they have excluded 452 alone, which is a section for punishment of, suppose you are the MD of a company and the company has given you a car, a Benz car, the car belongs to the company, and as an MD, that MD has been removed from the post of managing director. You know that the procedure for removal of managing director has been removed. Even after being removed, our man does not return the Benz car. It is still in his house, in his garage. So any concerned person, the company or the members, can file a complaint under this section. The ministry also can complain. The registrar, the regional director can complain, and the court then has to pass an order for restitution of the property back to the company. I mean, I'm not trying to go there. It will be taught separately. But that, since that needs a lot of examination of evidence, etc., they are not giving that power to the special court. Remember, what does the special court do? They do the same thing that was earlier done by a metropolitan magistrate or a first-class magistrate. Okay, let us understand this. If you understand it, you will understand prosecution, adjudication. ABC Limited is there. Under the Companies Act, ABC Limited is supposed to do many, many things. So many, every section, every chapter has certain duties. And if you don't perform those duties, if you do not comply with those, provisions, there is also a penal provision. Do you remember every time we discussed a particular group of sections, I told you about, or every faculty would have told you about the penalties. So at the end of the chapter, you will have a section that says, in case the company or officer, and if there is any violation of this section, the company and every officer in default will be punishable with a fine of so and so, continuing offense. In some cases, you said fine, imprisonment also. All this will come to a little more later when we come to compounding. But the point is, every chapter, almost every section has a duty, and that duty, if you don't perform, you are punished. Now, how will you be punished? How will this punishment happen? Who will punish you? So the initiation of this punishment will be by the Ministry of Corporate Affairs, the regional director. See, under the regional director, you have a lot of people. You have the registrar and all. So under the registrar, you have the deputy registrar, assistant registrar. Now, one of those deputy or assistant registrar would be called the assistant registrar prosecution. So whenever he goes through some documents or a case comes to him, or he just scans the documents filed by the company, etc. Remember, relate this to investigation. See, he calls for further information, it is not provided or it's provided. And finally, at the end of the inspection or investigation, the ministry or the regional director feels that this is an offense. So immediately they will initiate what is known as prosecution. How does it happen? They have to go to the jurisdictional magistrate. Now, so for the time being, ignore special court. Go before the special courts were formed. In fact, still the special courts have not been formed. So even today, it has to go to the jurisdiction. How do I decide the jurisdictional magistrate? Okay, not where the registrar's office is there, but where the company's registered office is there. If this company has a registered office in, say, for example, Coimbatore, then the jurisdictional magistrate would be Coimbatore. That too, they have to see which. See, this is linked again to the police station. See how beautifully the British have laid down this framework. For example, see, 100% everybody lives in a neighborhood, and every neighborhood in this country comes under one police station, right? So, for example, for me, possibly it is J3 police station or E3. Actually, it is E3. I mean, which is in Thenampen. For my house number, for my house where I am staying, the police station where I have to give a complaint for anything is E3. Then there is an alphabet for it, and so on and so forth. So now that police station will come under a jurisdiction of a magistrate. I think it will come under Egmore. In Chennai, it will come under the Metropolitan Magistrate, Egmore. So any offense committed in this neighborhood will have to be, the complaint will be filed before the prosecution will be before the Judicial Magistrate, Egmore, or maybe Saidapet. I really don't know. There are a lot of magistrates in Chennai, which is a pretty big city. This is the framework. So remember, when an offense under the Companies Act, for example, the company has not filed its annual return, or the company has not held the annual general meeting, it's an offense now. Definitely, and there's a punishment for it. So you have to go to now the complaint, the prosecution will go to the police station. Then go to the court. Then the court will take up the matter based on and they will call for they will give a summons. The matter will go. Remember, who is going? Let us say that, let's forget ABC Limited here. For a moment, let us take Dabur India Limited. Dabur India Limited has committed some minor offense under the Companies Act. For example, just giving an example to make the size of the company big. Okay, let us not take any known company. Let us say, Magna Limited. It's a top company in this country, 2,000 lakh crore turnover. They have committed an offense thanks to an inefficient company secretary who has not filed some stupid form. The company has committed an offense. or maybe the dividend was not paid on time, whatever. Some useless, I'm sorry to make that comment, but it's a responsibility of the company secretary. He has not done it and he'll run away. Okay, but then what happens? The notice will come. Who has to go to the magistrate court? The MD, the managing director of Magna Limited 2000 lakh crore company has to go and stand before the judicial magistrate. Sorry to say this, he will be standing in the company of. I'm sorry, this is not, I'm not trying to put the MD of such a huge company down, but the fact remains that this gentleman will have to stand in a queue as an accused, along with, pickpocket, prostitute, pimp, MD. So this is the queue. You can't say, I'm the MD of Magna. Sorry, the judicial system operates unfair, without any unfairness. It operates it is justice. Once you are accused, he is also accused, you are also accused. Maybe a different law, maybe a different offense, but both of you are accused. Come and stand here, answer your question and go. But then having come to the point, the Metropolitan Magistrate, who is handling this matter in Egmore or Saidapet, man doesn't know company law. Think about it. So the prosecutor will be there. The prosecutor is the guy who will explain the case to the court. And his job is to ensure that the offender is punished. So he will build an elaborate case against that offender and he will ensure that the punishment is there. Now the magistrate will ask, hey, what is the problem here? Kya hai problem? What is happening here? No, sir, they have not conducted a meeting. Nonsense. Every street corner people are conducting meetings. How this fellow cannot conduct? See, the guy, with all due regards to the judicial system, this guy is a magistrate now. I mean, even within the hierarchy of courts, it's not as if all of them are at the same level. Think about it. A judge of the High Court who has been in the bench for say 20 years, hearing tax cases and company law cases, tell me, definitely he knows more company law than a judicial magistrate. Possibly he knows IPC, boss. He may not know company law, and you can't teach him. But then still, what happens is we quickly explain to him, oh, he has not conducted meeting. Okay, it's an offense under Companies Act. Chalo, what is the penalty? 2,000 rupees. Pay. Order passed. Over. Convicted. The minute the magistrate passes an order, saying that there is an offense, it is called conviction. It's very important. You will have to link it with your Schedule 5, because conviction under any law, this gentleman cannot be appointed as an MD under Schedule 5. You remember one of the qualifications were link all these topics, then you will understand why conviction is very dangerous. Right? Okay, so that's it. Man comes home. Then if the MD consults you, you can give him a solution. What solution we'll come to later. Right now, the law has got its own course and it has gone ahead and done its job. Okay, in Tamil we say Sattam Dhan Paniye Cheyum or Sattam Dhan Kadamaye Cheyum. The judicial system has operated efficiently and punished. So this is the system. Unfortunately, the magistrate courts are flooded with such cases. Not only such cases. So what happened? They said, let's set up special courts. So empowered by the Special Courts Act 1979, the Companies Act has empowered the central government to set up special courts for the purpose of administering Companies Act, and the constitution of these special courts is a single judge, a single judge holding office as session judge or additional session judge in case of offences punishable under this act with imprisonment of 2 years or more. 2 years or more, you need a session judge or additional session judge, means a judge who is qualified to sit in the High Court. In case of offences which imprisonment is 2 years or more. But other than that, less than 2 years and any other offence, a metropolitan magistrate or a judicial magistrate of the first class. See, if you are not very clear about metropolitan magistrate, don't worry. Both are same. The judicial magistrate, metropolitan magistrate, executive magistrate, chief judicial magistrate, almost at par with small nuances. That's all. Metropolitan magistrate sits in the metropolitan cities, right? Whereas the judicial magistrate of the first class, non-metropolis. That's all. Whatever it is, it has to come before a metropolitan magistrate or a judicial magistrate. In case imprisonment of 2 years or more, the guy sitting there should be a session judge or an additional session judge. These people will be appointed by the central government with the concurrence of the Chief Justice of the High Court, within whose jurisdiction the judge to be appointed is working. See, in Tamil Nadu, we have a Chief Justice of the High Court of Madras High Court, topmost honcho. He is the guy who appoints everybody. He is the boss of the judges. Think about it. The judge sitting in his bench is an authority in that courtroom. But he has a boss, and that boss is the Chief Justice. In fact, the Chief Justice of the High Court decides who sits in which bench. They keep on changing. He also decides who sits in which jurisdiction as a magistrate, so on and so forth. So, obviously, which means central government cannot act on its own. It has to talk to the Chief Justice, and from his panel, he will select and say, hey, these people, and they will. Right? Purpose of this whole exercise is to provide speedy trial. The special court may exercise the same power which a magistrate having a jurisdiction to try a case under section 167 of the Code of Criminal Procedure in relation to an accused person who has been forwarded to him under that section. So, special courts, the power is the same. Earlier it was common where you had to go along with pickpocket, prostitute, pimp. Now there is a special court where only company law offences or offences under the Companies Act will be heard. So some kind of decency there. That's what I don't know. Okay. What decency in violating the law? Whoever, whether it's a violation of IPC or whether it's a violation of company law, accused is an accused, right? There was a view, but then they want to. The real purpose is not that. The real purpose is speedy trial. Okay, quickly finish the matter. Now, when trying an offence under this Act, a special court may also try an offence other than an offence under this Act with which the accused may be charged at the same trial. For example, there may be common violations under the Companies Act, Securities Control Regulation Act, SEBI. So, all these, they may be common. And they may be common, they have a common cause, but they are under different laws. So, this fellow is serial offender. He has offended so many sections under the Securities Control Regulation Act, SEBI, and Companies Act. Everywhere he has committed offences. And so now they are all coming together and saying, why waste time? Let the same special court hear all the matters and decide. So let him be, that's it. He will be locked up forever in his life. There are companies like that. You see, giving false information to remember, we'll go to 447, fraudulent activities. Those cases, SEBI also may be involved. SCRA may also be involved. So, because the public are also involved, yes, then it could happen, right? Jurisdiction. So, very, very important. Every judicial body has a jurisdiction. Jurisdiction is basically territorial. Territorial means geographical. Geographical area, I already gave you how that is determined. I already told you, be very, very careful. First, we have to ask, where is the registered office? Address, postal address. Then there is you can go to Google and search for every pin code. For every pin code, there is an attached police station. You can find out. It's available in Google. It's not some Masonic secret. It's available for you. It's a public information. Right. Once you arrive at the police station, then every police station is linked to a metropolitan magistrate or a civil magistrate. So you know the jurisdictional magistrate. Okay. So this is the link. So the first thing you have to know is where is the registered office, which is why the registered office is such an important thing. That is why we make such a big fuss about registered office in intermediate, and we also taught you how changing the registered office needs so much support. You can't just move from one state to another state without a without a review and without an approval, right? In fact, there was a quasi-judicial review when you're going from one state to the other. You needed to go to the tribunal, right? So, now the point here is, so based on the registered office, everything is linked. So, all offences specified under section 435(1) shall be triable only by the special court established for the area in which the registered office of the company in relation to which the offence is committed. So, the area should be linked to the registered office. All offences, which means even directorial offences, KMK, everybody, it will be linked to the registered office and they will have to go there. Which is why, I don't know if it's still there in their incorporation form. In those days, the registered office was intimated at the time of incorporation in a form called Form 18. Those days, I'm talking about old law. Currently, it's all a combined form, SPICE. Whatever it is, when you're giving the registered office address, we were also supposed to give the jurisdictional police station. it has to be filled up. And that's why I said we look it up based on PIN code. It's a publicly available. Check out. Check out what is your jurisdiction, who is your jurisdictional magistrate. So you need to go, which is your PIN code, wherever you are in this country. It doesn't matter. PIN code, police station, jurisdictional magistrate. It's a link. So this is the guy. Okay. Where there are more special courts than one for such area, the High Court will decide. Okay. For example, like in the case of the city of Chennai, the High Court decides. Don't worry. The jurisdictions are clearly laid down. There's no big deal. If at the time of prosecution, if the jurisdiction is wrongly filed, that itself is a dismissal. Appeal for that itself will dismiss the case. But be very careful while filing a prosecution proceeding. I don't know if I'm being too elaborate in explaining this, but I'm also not getting any questions or any indication about whether people are even listening to what I'm saying. So in case you have any queries, feel free to put it up on the query pad. No issues. So moving on with our topic, the special courts have certain powers, right, on people who are accused. So where a person accused of or suspected of the commission of an offense under this act. So all offenses under this act except 452, where a person accused of or suspected of the commission of an offense under this act is forwarded to a magistrate under section 167 of the Code of Criminal Procedure. See, usually the complaint will go usually to the police station. See, it is the police who decide whether to take it up to the court or not. But in this case, in the case of Companies Act, there is no need for a police because, see, the police administer the Indian Penal Code. So the Indian Penal Code, the administrative mechanism is the police. Suppose any offense under the Indian Penal Code, you are, as a citizen, you have to go to the nearest police station and you have to complain. There's a theft in your house. Then you have to find out your jurisdictional police station, go there and file a complaint. Then they will come and see whether there is a real theft or you are simply dying. In fact, today, believe me, you and I have to prove our innocence before they go for the thief. I'm sorry to say this. Okay. Then they will try to find the accused. And if by chance, by luck, the thief is located, then they will file a prosecution. They will forward this matter to the magistrate under section 167 of the Code of Criminal Procedure. Right? Yeah. So, yes, I think my jurisdictional code is Saidapet and not Egmore. Reason I say this is because my motorbike was stolen long ago in 1990, I think it was stolen. I would not want to go into the exact circumstances, how it was stolen. It's a little embarrassing for me. But anyway, suffice it to say, I was not very careful. I had not locked the bike and I was, so somebody stole it. And finally, luckily, I was engaged to be married and my father-in-law was a policeman. And so sort of police department. So he was able to push the matter and finally, they managed to locate. Wow. And I got the news that my motorbike was somewhere in South Tamil Nadu near Salem in Attur. I went all the way there, saw the poor vehicle, then I brought it back to Chennai at my expense along with the policeman. And then finally the case came for hearing and my motorbike was retained as evidence. So on the day of the hearing, I have to go there because my goal is to get my motorbike and come. But the accused is also there. I could actually see the guy who stole my bike. His name was Satish. He was standing there in the accused. And I was called to give witness. And the lawyer whom I had hired, said, sir, don't talk, don't open your mouth. Whatever the judge is asking, say yes. That's all you have to do. Don't do anything else. You won't waste your time. I thought here's an opportunity for me to give an elaborate pleading on how as a citizen I have been, just keep your mouth shut. So this magistrate, the judicial magistrate was metropolitan magistrate only was hearing. Said, what is the matter now? Okay, he said, the accused is standing there and I am the witness and also the man who has lost my motorbike. Said, what happened? Said, sir, his motorbike was stolen. Oh, Satish only stole it. Oh, okay. What does he want? He wants to, now that the matter is proved, he wants to take the motorbike back. Then the judge started abusing me. He said, sir, are you not responsible person? You are telling you are a chartered accountant. Should you not have more responsibility? Why you have not logged? Look here, I am the guy but this is the fellow who stole it. And that day was simply grinning and standing in the court. Whereas as a witness, I was suffering. And finally the court said, chalo, take it. Take your bike and run. So I felt as if somewhere I had become the accused in that proceeding. And I just ran away from that place. Luckily got my bike through a good friend who was a great advocate. And I sort of ran away from the Hyderabad High Court. Anyway, that was my brush with the law in a way. Right. So why I am telling this now, please do not commit any offense under any of these laws. It's a nasty thing to go before a magistrate court. It is not the way you see it in the movies and all that. It's a very, very dirty place, and you don't really want to go there. Believe me. Let this be a warning to your heart for your lifetime, never to commit any offense which will make you go before a judicial magistrate. Please do not. Please think 100 times before you decide to evade the law. See the benefit that you are getting and compare it with the shame of standing before a judicial magistrate, and then examine your conscience and act accordingly. It's my only humble suggestion, right? Now, so where a matter is forwarded, right, if that person is a judicial magistrate, this magistrate may authorize the detention of such person in such custody for a period not exceeding 15 days. Now, this is possible only where the offense is punishable by fine and imprisonment. Okay, fine and imprisonment or imprisonment. Where imprisonment there, then the judicial magistrate can retain him for 15 days. Whereas executive magistrate can retain him only for 7 days. So clearly these two guys are different. Now the judicial magistrate has more power than the executive magistrate. Small nuances. It's only in terms of power. Both of them sit in the same place. Both of them have jurisdiction over the same matters, but the powers are slightly different. For example, it's a promotion. The guy joins the judicial system as a magistrate, as an executive magistrate. Then if he performs well and with the number of service, he will become a judicial magistrate. Then he will become chief judicial magistrate and so on. This is only promotion within that, the judicial system. Okay. So the powers are slightly different. That's all. Now, suppose the magistrate considers that the detention of such person upon or before the expiry of that period of detention is unnecessary, he will order such person to be forwarded to the special court having jurisdiction. So the point here is, matter comes up before the normal magistrate, right? He goes through it. Then he finds that it's a company law offense and there's no need to retain this fellow in prison. So he says, take him out and forward the matter to the special court having jurisdiction. Cognizance is a very powerful word. We will talk about it a little more when we come to cognizable and non-cognizable offenses. But this is just to inform you that cognizance means recognition. The court will recognize a matter, okay, only when the complaint comes from the correct person. The court will recognize it. So that's why I said the process is there. So the company prosecutor is there, he has to go, then he will brief the company, the assistant registrar prosecution will brief an advocate, who will be the company prosecutor. Then that company prosecutor will appear before the court and he will file the prosecution papers. Then the court will take cognizance. So a special court may, upon the perusal of the police report of the facts constituting an offence under this act, or upon a complaint in that behalf, take cognizance of that offence without the accused being committed to it for trial. So normally the case will come before the special court only through the Ministry of Corporate Affairs, through the assistant registrar prosecution and the prosecutor. But if it is not done, even without that, if there is a complaint, for example, a company has not repaid deposits and the MD is trying to flee. So the public or the depositors go to the police and they file a complaint, and the police takes action and they produce this guy before the special court. Then even without the accused being committed to it for trial, merely based on the police report or upon a complaint, the special court can take action. They can proceed. In which case, the registrar of companies would be asked to come and give his view. he will also be summoned and asked to give his view as to whether this should be proceeded or not. So we already saw that special courts are established for the sole purpose of providing speedy trial of offences. But see, this is an opinion or a view, not necessarily. It can be seen that neither an adequate number of courts are established, nor do they dispose of the cases expeditiously. So the case, they have not been established, and still the problem is there. So in the matter of serious fraud investigation office and others, and Rahul Modi and versus Rahul Modi and others, the special court held that according to section 212(3) of the Companies Act, the investigation should be completed within the specified time. But if the investigation cannot be done on time, the authority can extend the time accordingly. So they keep saying this. The special court, see, the purpose is to give speedy relief. So if you're going to permit the serious fraud investigation office to continue with the investigation indefinitely, then where is the relief, is the point. So, of course, there's a famous saying, a legal maxim which says, delayed justice is denied justice. Delayed justice is denied justice. For example, if Mr. A has been accused of an offense and the court is still taking time to decide, suppose every day that the court does not decide, he is an accused. See, if he is truly innocent, this itself is a punishment, right, for him, because nobody will believe him because the court has not decided. So long as the court decides, you are an accused. So we have to give him speedy relief. Either if the case is proved, convict him or acquit him. Acquittal is a right. So speedy relief is the only way out for this. Right. Now, there is something called a summary trial. Now, the word summary has a very important meaning. Summary means prima facie on the facts, right? Where the facts presented are so clear, there is nothing more to discuss and waste. Okay, then why waste time with an elaborate trial, etc., etc. Okay, so where the offense is open and shut, see, there is a clear-cut section. Offense is there. The law has not done it. He is not able to produce any evidence to the contrary. The ministry has proved their case. That's it. Matter should be over. Sentence should be passed. So this power is given to the special court under 436, where they say the special court may, if it thinks fit, try in a summary way any offense under this act. Summary means quickly. Okay. Deal with the matter in a summarily means quickly. Don't keep wasting time. Where the facts are clear, where the situation is clear, where the facts speak for themselves, res ipso facto, where the facts speaks for itself, matter speaks for itself, then don't waste time on elaborate trial. Go for a summary proceeding. Okay. But the special court, where there is a punishable with imprisonment for a term not exceeding 3 years, it can go for summary proceeding. In case of conviction in a summary trial, they can pass a sentence of imprisonment only for a term of 1 year or less, not exceeding 1 year. So, if you want to go for a summary trial, the punishment cannot be for more than 1 year by way of imprisonment. So, remember, these are all offenses already proved. See, it's not as if this guy has any argument. He simply has to go, he's going to be punished. That's all. Okay. But if at the commencement of or in the course of a summary trial, it appears to the special court, the nature of the case is such that you should go for more than 1 year. The sentence should be for more than 1 year. Or it is not good to decide the case summarily, because there are many facts which are to be examined, which are, see, for example, the accused may produce facts, in his own defense. He is entitled to. And these facts cannot be so easily dismissed. They need to be examined. In those cases, the special court will hear the parties and then it will record an effect order that, sorry, the summary proceeding is wrong. We can go for an elaborate hearing and they will rehear the case in accordance with the procedure for a regular trial. See, the problem with a regular trial is that witnesses are to be heard. All the parties have to come, which is one of the reasons why lawyers earn a lot of money. Sorry to say this. Courts are delayed. So a lawyer goes to court in the morning and the other party may not come. Or the other party may come, he may not be ready for argument. Or we may go, we may not be ready for argument. So every time we appear before the court, we charge the client. But this is genuine. See, even the court sometimes, when you go there, they will say, case adjourned. Sir, we are ready for argument. Your Honor, we are ready for argument. Sorry, today no. Case adjourned. Next month, date will be fixed. That's all. Matter over. You have to go wait one more month. Till such time, the accused also has to wait. Prosecution has to wait. If it is a civil case, both the plaintiff and defendant have to wait. I mean, the judicial system definitely needs a lot of change. Sorry to say this. This is not told by me. This is told by very, very senior judges of the High Court, retired judges and judicial people, senior counsels and lawyers. Everybody opines that the current judicial system in India is too slow, right? You go to the US, it works so fast. Why US? Almost every European country, you have so many rights and rights and other. Nothing is there in India. See, so once you get caught by the machinery of the judicial system, you are dead. You are a fodder. Just have to go in and they will bang you up and send you out. Which is why I'm humbly suggesting to you, having decided to become such an educated individual in this country, one of the top educated individuals, you're going to become a chartered accountant. You will be one among, say, 2.5 lakh people in this country. Think about it. You are going to be unique. Okay? Only 2.5, little more than, I don't know the exact number, whatever it is, 3 lakhs, whatever. In a country of 1 billion people, we are very unique. We chartered accountants are very unique. We represent an important profession in the society. And having got that type of recognition, don't you think we should obey the law? Don't you think we should accept that the law is binding us and we should try our best not to get into a judicial system as an accused? Because when that happens, when a chartered accountant stands up in a court as an accused, remember, he is also shaming the profession. He or she is shaming the profession. The profession is also shamed, which is why, you and I have a duty as members of this glorious profession, never to commit any offense or never to permit a company where we are employed or advising to commit an offense, right? Which is also important because sometimes that is also wrong. Good. Suppose you are not happy with the order of the magistrate, the special court or the judicial magistrate, then the High Court will become the appellate body. So the High Court will exercise the power of appeals, reference and revision. Okay. See, difference between appeal and revision is, appeal is where you are not happy with the order and you want to present the facts again to the High Court and argue the law. Agreed, go to the High Court. Sometimes the order of the High Court, the lower court, the magistrate court may be bad in law. Straight away it's wrong. There is a clear-cut mistake. Particular matter was not covered in that order. Then you can go for a revision petition. You can tell the High Court, sir, please revise this order because I don't have to prove any more facts. Everything was presented. It's all on record. Our man, while passing the order, has not considered that evidence. It's wrong. Please revise it. So revision also is possible. Where there's no need for further hearing. The documents which are submitted to the High Court, that alone is enough. And by seeing it, the higher authority will say, hey, what nonsense. This fellow has already submitted this. How can you say he has not? Over. Revising. Revision of the order will happen. Right? So this power of revision and appeal is very important. Okay? Appellate jurisdiction and revision. Where there is a particular question of law which the magistrate is not able to answer at his level, he can refer the matter to the Judicial High Court on a reference, on a specific question of law where he might say, look here, I don't want to take a risk. You fellows go there, on this question of law, let the High Court give the answer. Then then we will go ahead and continue with the matter like that. Okay? That is called reference, right? Okay. So moving on, I know this is a very, very straightforward subject. Agreed, could be a little boring when you're reading it in the material, but I hope, we are relating it to the real life situations in around you. Okay. Right. So the High Court will be exercising the appellate, referential and revisionary jurisdiction again based on the local limits of the jurisdiction of the High Court. So jurisdiction is very beautifully laid down in India. See, if a lawyer wants to really trouble the High Court, he can try jurisdiction, but very difficult. Unless the other party has made a stupid mistake and filed a suit in the wrong jurisdiction. Okay, that's a classic ladde, where simply one simple defense would be, court does not have jurisdiction, Your Honor. Now, oh, really? Is it so? Who has the, oh my God, no. Case dismissed. Okay, now what happens, the man has to go back to square one. It's like the snakes and ladders game, where, this guy is now on that long snake or medium snake, he'll come down back to the number 3. Okay, point number 3, just again start the proceeding. Okay, which is why if at all you are filing a civil suit be careful. Well, of course, you're not going to do it. Go to a good advocate and they will ensure that the jurisdiction is correctly filed. It's one of their jobs. Okay, but as a chartered accountant, it's good for you to have a little bit of knowledge of these things so that you're not totally ignorant. So, what does all this mean in plain English? It means all appeals and revision applications against orders of a special court shall lie before the jurisdictional High Court. Okay, that's all it means. In fact, when you're reading the institute material, remember, in most cases, the Board of Studies has correctly given the original section content in the material. Original section content in the material, which is good. They are very safe because if you try to use your own words, sometimes you could go wrong. Right? With, of course, some exceptions where we have tried our best to simplify it for you and give it. But the point here is sometimes these original sections are a little too elaborate. Okay, so you might want to convert it into plain English once in a while. Which is what you will find in most of my PowerPoint presentations or notes that I have shared with you. What I would have attempted is, I would have read the section, wherever possible, I would have tried to simplify it and give it in plain English without shall we say, damaging the original meaning of that section, which is very difficult with Companies Act 2013 because the Act itself is loosely drafted, not drafted by loose. It is loosely drafted. It is not tight. The language used is not tight, and the language used is casual, sometimes ungrammatical too, which could lead to a lot of, shall we say, ambiguity, right? Sometimes it's downright ungrammatical. Straight away, it's ungrammatical English. And I'll be tempted to add that preposition or that verb or that adverb there, which would make that meaning. But sorry, we can't add one word or remove one word from a enacted law in Parliament. Only the Parliament can reenact it, amend it. Now, the Code of Criminal Procedure will apply. See, remember, 435 and 436 apply notwithstanding anything contained in the Code of Criminal Procedure. So these are exceptions to the code. But subject to 435 and 436, the Criminal Procedure Code will apply to proceedings before the special court. There are so many forms, there are so many methods, there are so many rules. All that will apply to the special court also. Okay, and the special court shall be deemed to be the court of session or the court of metropolitan magistrate. Again, what is court of session? Metropolitan, simple. In a metropolitan city, it is called the metropolitan court. Outside of the metropolitan cities, it is called court of session. That's all. Nothing great. See, this is as old as the British. So when the British came to India, they set up 4 presidency towns. You had rather 3, then the 4th came. Okay, so you had Kolkata the first, Chennai the second, Delhi, and Mumbai. Okay, sorry to say that order. It came because Fort William, Mumbai came later, but the first was Kolkata. The oldest metropolis was Kolkata. Then we had Chennai, Madras Presidency as it was then called, and it's okay, Madras Presidency. And then you had Delhi, and then Mumbai. So each of which sort of developed, became metropolitan cities and huge. And the rest of them were called courts of session. So the same guy who sits in Madras would go to Coimbatore and sit in a court of session, and so on and so forth. So they were called sessions judges. Right? Think about these white men now. Instead of enjoying their life in their own country, Solos came all the way to the tropical sun of India, and they toiled to, give us a judicial system, give us a railway. I don't know. And maybe they got some benefit out of it. But then I think 20% of the British raped our country and took all the wealth. But the remaining 80% fellows really served our country and really made our country what it is today. I repeat, only but 20% raped. 20% of them raped our country. They took all the natural resources, rascals, and they deserve to be punished, which they never got punished. When thanks to the decision we took, we let them go scot-free. We didn't, no reparation, nothing. Simply we saluted them, we fell at his feet and we sent him out of this country. But the remaining 80% civil servants, magistrates, police officers, they honorably served this country. Forest officers like Jim Corbett. Remember, Jim Corbett was a forest officer who was protecting he was in charge for protecting the wildlife. He has done much more for the wildlife in India than Indians, if I may say so. Okay, so on and so forth. Okay, I'm not an Anglo, definitely I'm a little bit of an Anglophile, but the fact remains that, these guys, poor fellows, which is what Kipling says, Rudyard Kipling many times says, why the hell did I come to this country to serve these people? And he makes a thing out of it. Because these guys came to this country, Kipling and Corbett, and all of them, William Jones, they came to this country and they fell in love with it and they sort of became part of it. Of course, you had people like Macaulay, you had people like Lord. They raped our country. I'm not trying to deny their atrocity, but having said that, these guys also seem to have done some sort of a good thing for us. That's what I would say. Okay, in case the special courts are not formed, what happens? Until a special court is formed for a particular jurisdiction, the cases will be tried by the court of session or the court of the metropolitan magistrate or a judicial magistrate of the first class, as the case may be, exercising jurisdiction over the area. So, till a special court is established, the existing jurisdictional magistrate would take up the matter. That is why I elaborately explained to you the whole judicial system which is operating. And now remember, my dear friends, okay, all this is only with respect to offences committed under the Companies Act. Offences committed under the Companies Act. There are other proceedings also under the Companies Act. Remember, there are other proceedings also. Where there is an offence under the Companies Act, you have to punish the offender, etc., etc. But there are other proceedings. For example, you want to shift your registered office from one state to another. In those days, I'm talking about 1980s, etc., you had to go to the High Court. There was a special company court. Okay, minority, majority. Suppose oppression and mismanagement. You want to file an application. In those days, 391, 396, 397. You want to file an application for oppression or mismanagement. You have to go to the High Court. Winding up. If you want to wind up a company, you have to go to the High Court. They had a company, there was a separate bench, company law bench, where a very, very learned high court judge will sit, or a bench of 2 or 3 more people will sit and hear the matters. So the company court was there. Okay. Why I make this point, punishing offences, lower court, magistrate court. But anything relating to the section where, for example, you want to file a case for oppression and mismanagement, you have to go to the High Court, the jurisdictional company law bench. You have to go there and file a case, so on and so forth. Why I make this point here, no, don't confuse the two is all I'm trying to say. And today, what happened, why today? As early as 1980s, it was obvious that the High Court cannot handle this. So slowly, they started, delegating these powers of the High Court to another body which was established within the system called the Company Law Board. They established a Company Law Board within the framework of the Ministry of Law and Justice, then Ministry of Law and Justice, and they gave a lot of powers to this body. So that was called the Company Law Board earlier. And now it's not there. It has been replaced by our NCLT and NCLAT. So when I come to NCLT, remember, offences under the Act punishable still by the court, the lower courts or the special courts. But other matters like shifting of register office, winding up of a property petition for winding up, or oppression or mismanagement application, merger where you want to merge 2 companies, the application, the scheme has to be presented to all this goes to the tribunal. Earlier, all this was heard by a high court. All this was heard by a bench of the high court, special bench of the high court. Now, earlier means around the 80s. Once the company law board came, all this got shifted slowly to the CLB. But till recently, till 2000, till this new law came, almost till recently, 1990, 2000, 99, 2000, 2001, the act was amended to transfer all this power to the company law board. But it was not done. Courts were still hearing. So many winding up petitions were being heard by the court. So finally, when the 2013 law came, straight away all that was removed. And then the tribunal, the NCLT was established. Then the new law ensured that all matters are now heard by the National Company Law Tribunal. So there the courts, we have said no, because it took further long time. So they said, we need some body which can immediately hear and finish it. So the NCLT has formed for hearing these matters and passing orders within the framework of the Companies Act. Okay. Did things become very fast? To an extent, yes. To an extent, yes. I mean, as against huge delays which used to happen in those days, because you are totally dependent on the court calendar, right? Now the NCLT definitely gives you a faster thing. Provided your documentation is good, you can go faster. If you have the right company secretary and the right advocate, and they advise you correctly, you can quickly move to and finish the matter and come out of the National Company Law. Okay. More about it when we come to NCLT. Again, just want you to understand. For a prosecution of an offence under this act, you will not go to NCLT. NCLT has no power there. You will have to go to the jurisdictional magistrate. Right. So we have sort of completed the concept relating to special courts. Right. Now we move to another concept called non-cognizable and cognizable. Right. See, basically, the Criminal Procedure Code lays down the concept of cognizability and non-cognizability. This is based on the seriousness of the offense. The seriousness of the offense. Right. So, what is an offense? First, be very clear on offense. There is a law passed in Parliament which says you have to do something. You have not done it. Or there is a law passed by Parliament which says you should not do something, you have done it. The law says you should do it, you have not done it. The law says you should not do it, you have done it. Offense. That's all. Not doing something which is prohibited by law, not doing something which is mandated by law. Doing something which is prohibited by law, not doing something which is mandated by law. Both are offenses. Both not doing action and doing action which is against the law. Both are. Okay. For example, even though you and I'm humbly suggesting you don't get caught in the judicial system and all that. Definitely don't commit offenses under Companies Act, FEMA, all that. Knowingly don't go and do it because you are a chartered accountant. You can't do this. But most of us at one time or the other would have been caught under the Motor Vehicles Act. See, the Motor Vehicles Act is an ubiquitous law. The minute you are driving a two-wheeler or a four-wheeler, you are exposed to the Motor Vehicles Act. You have to abide by the Motor Vehicles Act. Remember, when the driving license was given to you, you agreed that you signed a document by which you agreed that you will comply with the letter and spirit of the Motor Vehicles Act. My humble request, please read the Motor Vehicles Act and find out what are all the offences there. You'll be very, very surprised about the type of offences under the Motor Vehicles Act. For your information, you cannot take an animal in a motor vehicle. Sorry, just check out at least under the Tamil Nadu Motor Vehicles Act, you cannot take an animal in a motor vehicle which is moving. Every time I drive on the road, I see a dog putting its head out of the car and wagging its tail. And it's nice. We also wave with the dog and all, but it is an offense under the Motor Vehicles Act. Okay, seriously, they can stop you and ask you, what are you doing here? Seriously. Okay, of course, smoking in a public place is an offense under the Indian Penal Code. Public place now defined to include motor vehicle. A moving vehicle or even a stationary vehicle is a public place. You can't say, sir, it's my own car. can I not smoke in my own car? Sorry, smoking is injurious to health, but then that is not the reason. You are also injuring other people's health. So don't smoke in the car. If you obey all this, think about it. So 100% you will be committing many offenses on a daily basis under the Motor Vehicles Act, right? So now you understood what an offense is, right? So suppose the police catch you red-handed doing something. For example, there is a one-way street where you're not allowed to go up, but you're only allowed to come down. And because it's a shorter route to go to wherever you want to go, you quickly go into that route and come. Police will be waiting on the other side. Rarely will the police be here preventing you. The police will be standing on the other side catching you. See how beautifully the police operates. They should be sitting here saying, don't go. No, why should they? They said, after all, you should know it. So they stand on the other side and anybody who comes, they catch. Offense under the Motor Vehicles Act. Okay? How do I say it's cognizable or non-cognizable? It has to be, it's based on the seriousness. Motor Vehicles Act offense is not so serious. So basically it is non-cognizable. Okay. Whereas, suppose somebody is stolen in the market, in the busy bazaar, the fellow steals a gold jewelry from a lady, snatches the chain and starts running, and he is apprehended and handed over to the police. This is a cognizable offense. It's very serious. Okay, serious. Now, which means the difference cognizable, non-cognizable. Normally, they will say cognizable offenses are non-bailable, whereas non-cognizable offenses are bailable. Okay, where an offense involves punishment by way of imprisonment, where the punishment is by way of imprisonment, the police can keep you in custody. You as a citizen have a right to go before the judicial authority. You are to be produced before the judicial authority within 24 hours. Under the Criminal Procedure Code, as a citizen, if you have been taken into custody, maybe they have a case which they may prove, they take you. If you're caught red-handed, no need for a warrant. Otherwise, they will bring a warrant and show and then search your premises. Maybe they come out with something, they say it's an offense under so-and-so act, arrested. So anyway, they put you in the van and take you there. They can keep you for 24 hours. Next day, or the next working day, they have to bring you before the court. Bring him before the court. Okay? And then the court will decide. So, where it's non-cognizable, where the offense is non-cognizable, you are entitled to bail on your own, shall we say, word. On your own word, you are entitled to bail. There is no further, your word itself is the bond. You can just give a oral bond. I will not go out of the state. I will come whenever I am called. I will appear, Your Honor. Then immediately bail granted. Go. So you'll be out on bail. Okay, doesn't mean you are not guilty. You will have to come regularly, argue the case. It is bail. So this is only for cases where imprisonment is involved. Mere fine, no problem, because you see they will summon you. You go to court, pay the fine, come out. That's all. Matter over. Imprisonment. So you can ask for bail. On the logic that you can say, look here. As of now, I am an accused. Don't put me in jail. Because if I am in jail, then how can that means I'm already accused. Yeah, you are proving. So, and this will be recognized by the British jurisprudence. It's correct, absolutely correct. A man is innocent until proven guilty. So, on his own bond, I will release him. Or else they might fix the bail at a certain amount and say, deposit the amount and take bail. Bail is granted as a matter of routine, it is granted for non-cognizable offenses. But for cognizable offenses, bail is not automatic. The public prosecutor will be asked to take up the case and he will argue that the bail should not be granted. And only after hearing why the bail should not be granted, finally the court will decide. Both the views are heard. The accused is saying, I need bail. The other party. So these will be cognizable offenses only. This whole thing will happen because they are serious issues. For example, a famous hotel owner in Chennai, he committed a very, very heinous murder. He was the man who instigated it. Though the murder was actually committed by his employees, it was clearly proved that he is the person, and he was arrested. Now, that is a case where it's a clear cognizable offense. premeditated first-degree murder. So man was accused. So he was finally granted bail under heavy conditions. But the bail was opposed by the state government, where they said, don't give bail. The reason is, if he goes out, he will destroy the evidence. Suppose you let him out on a bail now, the first thing he will do is start destroying evidence. He's such a powerful person. So no, we can't let him out. So on and so forth. So don't get confused about cognizable and non-cognizable. Basically, cognizable offenses are slightly serious offenses like murder, theft and all. Bail is not automatic. Whereas non-cognizable offenses are, bail is automatic. If there is a punishment by way of imprisonment, the court can give you bail till such time you are proved guilty. Once you are proved guilty, sorry, go to jail. But till that time, you can be free and walking in the road if it's a non-cognizable offenses. Means, after all, think about it. The person is a company secretary. Some offense is committed by the company. Unfortunately, that offense involves imprisonment. So the Ministry of Corporate Affairs will try to say, put him in jail. So the court will say, no. He's entitled to, after all, he's a member of the Institute of Company Secretary, he's a well-known person. Put him on, I'll give him bail. Bail is automatic. So this is very important that all offences under the Companies Act, except offence under Section 212(6), shall be deemed to be non-cognizable. Non-cognizable within the meaning of the Criminal Procedure Code. That means what? Bail is automatic. You can go there and stand up and say, even if it involves imprisonment, you can say, please give me bail, and the court will give you bail. It will not be opposed, right? So, except 212(6), all other offences are non-cognizable. Right? Who can file the complaint? This becomes very, very important. See, there might be an offence. But everybody cannot file a complaint against it. There should be somebody who is entitled to make the complaint. This is called the plaintiff, the proper plaintiff. Usually, to explain this, I will give a story. Let me do that for you also. Many students from across the country, especially Odisha, and Andhra Pradesh, and Kerala, they come to Chennai for attending coaching classes. So they stay in mansions in areas like Triplicate and Roypeta. There are mansions which provide reasonably priced accommodation. They also serve food and all for these students. So those areas, if you go, many senior chartered accountants today, they will have fond memories of their stay in Chennai, where they used to stay and study in these mansions. Okay, when I go to Visakhapatnam or other places, they remember, Srikanth, I used to stay in Chennai. I used to stay in Triplicate in that mansion. Like that, they used to stay. So these guys come and stay there and study. They become members. Then they go back to their native place or Mumbai, Delhi on a job, whatever. Now, the point here is, one of our friends who's come like that, he's studying in his room in the mansion in the 5th floor. And next door, there's a terrace. From his window, he can see the terrace. And the lady, that next door lady, married lady, she is putting up the clothes, drying for drying, and she is crying, weeping. And every day, our man hears the sound of her husband beating her. The husband is abusing her and beating her. She is, marital abuse. So she is suffering. And he knows that. And this guy's heart is opened and he says, my God, this is an offense. Yeah, it is an offense. So he goes to the jurisdictional police station and he files a complaint. And he says this particular lady is being abused by her husband like that. Chalo, no problem. So the policeman says, okay, sir, give your complaint. We will not register an FIR. Just give the complaint and go. Today evening, we will take it up. So they will send a message to the husband saying, come, report to the police station. So the husband will come. You will also be called because you are the complainant. This gentleman also will be called. The student also will be called. Because you are such a socially active person, you will be called. And the husband will come. Of course, the wife will come running. The wife will come running, beating her, breast and shouting. And she will tell the police, who is that rascal who complained about my husband? Who is the rascal who complained about my husband? My husband is such a great man. What he does to me is his problem. Within my house, he will beat me, he will hit me. What is your problem? He'll start abusing. That is the nature of the Indian woman, that, she will put up with any amount of abuse in a marital situation, then go to the police and complaint. I mean, I'm sorry, I'm telling you this very, very cynically, but and the student who is honorably, he will be abused first. She will tell, you rascal, who are you to complain, man? Get out. Like that, she will say, and the complaint will be withdrawn and she will go home. The point here is, who is the right person who can make that complaint? Who is the right person? See, there should be everybody and anybody cannot complain on every matter. So the right person is only the affected party. The affected party only can file a complaint. So others, definitely they can. But which is why, NGOs and activists, what we do, we go to that lady and we try to convince her to get the strength to come out of this stupid relationship, file a complaint and go for divorce and get out of that losing life. But that's different. That's for a psychologist and an activist and a counselor to do it. That comes later. Third party, unconnected third party cannot go and give a complaint. Right. This fellow, this guy staying in the mansion, is on the other side, on the other side. This side, one story. Another side, he sees a very big bungalow and is an MD of a large company. He has got 2 Benz cars and all. This man is getting angry. Fellow is so rich. I am so poor and I have to struggle in this mansion. Let me see. So he goes to the MCA website and he finds that the company where he is an MD has committed many offences under the Companies Act. Series of our fellow has now learned company law very well, so he knows what is the offence and all. So fantastic. So the guy immediately goes to the police and complains and says, so and so MD of so and so company has committed these offences, section 92, section 112, section blah blah blah. All these section offences are there. The police will simply laugh, tear up that and say, sir, you cannot give this complaint. We will recognize this complaint, or the court will recognize this complaint only if it is received from the registrar. Or are you a shareholder of his company? Are you a member of any of the companies where he is MD? Then maybe. Or are you a person authorized by the central government in this behalf? If you are not one of these 3, sorry, we cannot take cognizance of the offences. Are you able to understand? So, offence under the Companies Act, which is alleged to have been committed by any company or any officer thereof, is cognizable only on a written complaint by the registrar. See, I told you, in the registrar's office, you'll have an assistant registrar prosecution. That gentleman will file the written complaint before the jurisdictional magistrate court. Okay, only then action will be taken. The court will not recognize or give cognizance to complaint received from unknown third party. Right? This is, of course, the point here is the affected party should come and complain. Otherwise, what will happen now? Finally, the complaint will be made and the affected party will say, no, go back to Foss versus Harbottle. Proper plaintiff. Only the members who are affected can file. And that too, the company is the proper plaintiff, and that too, the majority of the members. Okay? Only, suppose a single member files also, it may not work. Unless, the law authorizes a single member to file. As in the case of oppression and mismanagement, or things like that, a member can complain, then you can do. Otherwise, no. So, written complaint by registrar or shareholder or member or a person authorized in this behalf. In case of offences relating to issue and transfer of securities and non-payment of dividend, then a person authorized by the SEBI has to file the complaint, right? So, I hope you have understood the meaning of the term cognizable and non-cognizable, right? And remember, all offences under the Companies Act 2013 shall be deemed to be non-cognizable, right? And therefore, a written complaint is required from any of these persons. If that is not there, the police or the court cannot take cognizance of the offence, right? Now, very, very important point. Let me rather state it as a problem, right? Let me rather state it as a problem, which is, here is the managing director of Magna Limited. Here is the managing director of Magna Limited. The company has committed many offences. Complaints have gone to the registrar. The investigation proceedings have happened. The investigation results in many offences being discovered. and proceedings are being taken against this gentleman, right? Under the Companies Act, prosecution proceedings. So matters are going to be filed before the jurisdictional special court or the magistrate court, right? Or it might even have been filed, or a complaint is being filed, or the matter is being now heard by the tribunal, say possibly under operation and mismanagement, whatever. The tribunal comes across some offences being committed, and then it will refer the matter to the special court. Whatever it is, there is an offence. You already saw what is an offence. Offence is the committing of something wrong or prohibited by law. Doing something which you are not supposed to do, not doing something which you are supposed to do. Both are offences. It is a violation of any law and is not restricted to committing of a crime. See, stealing, telling lies. Telling lies is not an offence under the Criminal Procedure Code. Sorry, nowhere in the CRPC have I said telling a lie as an offence. But yes, perjury is an offence. In the court of law, if you tell a lie under oath, it is an offence. Okay. So, having said that, burglary, murder, these are all crimes. But offences under the Companies Act are not crimes. Please understand, there is a difference between a crime and an offence. An offence is merely violation, whereas a crime is an offence against the society. See, when one person's house is burgled, then every one of us is in danger. Every society is in danger. So, such offences are called criminal offences, where it's committed against society, which is why your check bouncing is a criminal offence. 138 is a criminal offence because though bouncing a check is basically a commercial matter, still, fact that somebody bounced the check will create, shall we say, mistrust in the banking system itself, and nobody will want to accept checks anymore. Therefore, the person who bounced the check knowingly, without sufficient funds, he gave the check, should be punished. Therefore, it's a crime. Like that. So, basically, there are, under the Companies Act, there are no crimes, only offences. Okay. As I mentioned to you earlier, even an omission to perform a duty imposed by law is an offence. Not doing something is also an offence. Right? So, now offences under the Companies Act, by now you have seen so many offences and you are aware that, and many times, when I taught the particular penal provision, I might have asked you to, specifically see whether it is only fine or imprisonment or fine and imprisonment. Because these words are very important. Because if you want to go for compounding of an offence, okay, what is compounding? Don't worry. If you want to go for compounding, then you can do so only in some cases. For example, where the offence is punishable by fine only, or fine or imprisonment, or fine or imprisonment, or both. So where the word is or, fine only or fine or imprisonment. See, an option is given to the court either to levy a fine or imprisonment. So when the option is there, where the judicial authority has an option to go for a fine or imprisonment, okay, or both, then those offences are compoundable. They are compoundable. Whereas if the offence is punishable by fine and imprisonment, that's why, whenever you see an offence punishable by fine and imprisonment, sorry, not compoundable under the Companies Act. Okay. Similarly, if it is imprisonment only, then it is not compoundable under the Companies Act. Right? Now you will want to definitely ask me, Chalo sir, what you have been telling compounding. What is this compounding? Right? Now, compounding is the process of having the proceedings dropped. The accused will be recorded as acquitted. Now, why is this important? Please note, my dear friends, relate this to appointment of managerial personnel. Unless you do that, you will not be able to see the significance. As I mentioned earlier, if you want to go through the procedure of Schedule 5, if you want to be able to pay this man remuneration even in a year of loss or inadequate profit, if you remember your Schedule 5, you have to appoint him under Schedule 5. The framework of Schedule 5 very clearly says if he is convicted for an offense, any offense under those laws, including the Companies Act, if he is convicted and fined 1,000 rupees, then he cannot be appointed under Schedule 5. Right? It is a disqualification. So, and you also remember conviction can lead to disqualification also. So, by going through the process of compounding, you can avoid conviction. Though an offense has been committed, since it's not very serious and it is punishable by fine only, it is the discretionary power of the Ministry of Corporate Affairs to consider this offense and say, okay, chalo, first time offense, man honestly was not aware, he made a mistake, pay the compounding fee. Of course, pay the fine, pay the compounding fee, pay the compounding fee, and we will withdraw the proceedings and you will be recorded as acquitted. Even if the prosecution proceedings have commenced, even if the complaint has gone before the court, even then, even before the order is passed, before the order for conviction is passed by the court, at any stage, you can go for compounding. The compounding fee will be 3 times the fine. Pretty huge. But remember, you are the MD of Magna Limited, a reputable man. The minute you go and stand in that metropolitan court as an accused, first thing the press will come and take a photograph. The first thing is the press will come, where you are going to stand in a queue, along with who? Pickpocket, prostitute, pimp, MD of Magna Limited. Photo will be coming in the Times of India. No. Even as an accused. So you want to avoid all that shame? No problem. Come for compounding, finish it off. So compounding is the method by which we enter into the department of the Ministry of Corporate Affairs is willing to compromise. Chalo, we'll help you. But they can do that only for these cases, where it is fine and imprisonment or imprisonment only, the magistrate. There, you have compounding there also. In these 2 cases also you have compounding, but not within the framework of the Companies Act. You have to go for, under the CRPC, you have to compound. And there the power to sanction compounding is with the jurisdictional magistrate. He will have to take the call there. Okay? It cannot be done by the ministry. Whereas, if it is fine only, or fine or imprisonment or both, the Ministry of Corporate Affairs can take that call. They can withdraw the complaint. Okay? So compounding is a facility given mostly for economic offenses. Of course, even for criminal offenses you can do, but then there it's a totally different thing. For example, under the CRPC, you can't compound for all offenses. For example, so they have clear cut. For example, premeditated murder, you cannot say, I'll compound it. No. Similarly, the complainant cannot withdraw. Once a criminal complaint is filed under the CRPC, under the Indian Penal Code, you cannot come and say, I will withdraw it. No. For example, A has murdered B and B's children complain. Okay. Then later on, A and the children of B come into compromise. And A says, I'll pay you some blood money, take it and go. Now they can't go and withdraw the case. Sorry. In the Indian jurisprudence, the Indian judicial system, so no blood money and all. You have to jolly well go to prison and suffer. You cannot pay some blood money and walk away from the crime. Right? So you have to go to prison and suffer. Of course, you can compound for certain offenses, minor offenses, not for such heinous crimes like murder. Compoundable offenses are those offenses where the MCA, see, the Ministry of Corporate Affairs is the complainant who has initiated the proceedings. So this Ministry of Corporate Affairs agrees to have the charges dropped against the accused. Remember, this is a discretionary power of the Ministry of Corporate Affairs. It is not at the option of the accused. The accused can only go and request for compounding. The application is made for compounding. Usually it will be favorably heard, the compounding, because they also, I'll tell you, the ministry also wants to, because remember, every prosecution, they have to go to court. That list will be huge. So they also don't want too many prosecutions. So they are saying, okay, you made the mistake. Please don't do it in future. Correct it and then come and compound it. Okay. See, compounding is possible even under the Income Tax Act. For example, non-filing of TDS returns, non-remittance of TDS, serious offense, prosecutable offense. Non-deduction penalty, penal offense. Non-remittance after deduction, prosecutable offense. Matter goes before the magistrate. Right. You want to avoid it, you go to the chief commissioner and you make an application for compounding. Pay the compounding fee, you are escaped. I have done it for many of my clients where they had TDS violations. Again, because of some useless chartered accountant or company secretary. See, I'm telling you, I'm saying useless. See, after all, we are taking money, either as a fee or as a salary. Should we not do our duty? Okay, that's not fair. No, that is the ultimate offense according to me. When a professional does not, see, if you don't know, say you don't know and don't get into it. But if you know and don't do it in all fairness. Okay, I feel very unhappy when my fellow professionals, actively violate the law. Because after all, you and I, we are teaching the law to the client. How can we violate it? So it's okay. It's okay. If somebody is violated, they are prosecuted. We can go for compounding and we can get the proceedings dropped. Okay. Non-compoundable offenses are those which are not compoundable because of the grievous nature or seriousness of the offense. Obviously, because see, for example, non-payment of dividend, fine and imprisonment, not compoundable under the Companies Act, because you're supposed to pay the dividend to the shareholders within 30 days, and you are otherwise within 7 days you have to deposit it in a separate account. Not done that, fine and imprisonment. Right. Now, who can compound? It's another important question, right? Who can compound? So we have a monetary ceiling for that, where the fine is up to 25 lakhs. Sorry, up to and including 25 lakhs. 25 and below. Then the regional director himself can do it. So the regional director or any other officer authorized by central government can do it. Matter will go to the regional director, which is pretty good here. 25 lakhs is pretty much there. RD has substantial powers. In fact, this is one important power of the regional director, the power to compound. So many compounding petition applications will be pending before him. He will hear two things he will ask. One, is the offense made good? Have you complied now? So you are not supposed, have you filed? Suppose you have not filed the annual report or you have not filed the charge or registered the charge. Have you done it? Have you complied? Have you paid the fee, etc., etc.? Yes, done. Then please kindly confirm that in future you will not do this and that you will abide by the law. Yes, sir, agreed. Compound. Straight away you can go for compound. Suppose the fine amount exceeds 25 lakhs, then only the tribunal can compound it. So tribunal here, NCLT. Suppose I use the abbreviation NCLT, then don't get worried. It is not something else. It is the National Company Law Tribunal. Okay. Now, the offence will be compounded on payment or credit by the company, or as the case may be, the officer, of such sum as may be fixed. It is there in the rules, the compounding rules are there. Under that, for every offence they have, for example, sometimes it is 3 times the fine, 5 times the fine, etc. No problem, pay it. Because remember, what you are avoiding is shame, standing in a magistrate court. Provided that the sum so specified shall not in any case exceed the maximum amount of the fine which may be imposed. So the maximum ceiling is the amount. If you remember, most offences have a fine which is minimum and maximum. Now, the compounding fee cannot exceed the maximum ceiling under the Companies Act. Whereas under the Income Tax Act, it is 3 times. Under the Companies Act, they are magnanimous and they are permitting you. Maximum is the maximum amount of fine. Of course, when you go before the authority, regional director, you can again fall at his feet and say, sir, I am a poor man, I can't pay, please help me. Then he will fix it within that framework. This discretionary power is with the regional director. Right. Now, of course, I'm somewhat, I don't know. There are no, usually there will be a lot of queries. Today, I'm not having that. Today, I'm not having any query except assurance from Mr. Naveen Prakash that there is no doubt, for which I thank him. So as of now, we have reached a particular stage in our learning in this class. Before we proceed further into this topic, on special courts, NCLT, etc. Let's have a small break for say 10 minutes. My times, it looks like 8:40 a.m. So 10 minutes. We'll again assemble at 8:50 a.m. Of course, if you have any doubts from what I have told, feel free to raise any query on the query pad. Looking forward to your interaction on the query pad. Okay. Some of you are listening, and if you're getting some good inputs, why don't you just give me a feedback on the query pad saying, yeah, we are there. Okay, or whatever. So let's meet again at 8:50. Don't go away. Be back for further knowledge on prosecution under the Companies Act. Welcome back from the well-deserved tea break. Moving on with compounding. Of course, I don't see any queries in the pad, which means that, let me here quote a great member of our institute and a past president, my guru, the man who taught possibly lakhs of people in the southern region have learned income tax from this person. The southern region, to my knowledge, is he was the teacher of income tax. He is still, even if today Sri R. Bhubadi, CA Sri R. Bhubadi is conducting a class on income tax, you will find 55-year-old people like me will go and sit in that class to listen to him again, because such was his greatness as a teacher. Having said that, he was also a sort of a mentor when I started teaching and all that. Bhubadi sir used to sort of teach in the same building, and sometimes he used to come down and call me, and then out of his own love and affection and grace, he used to call me and give me some tips on what to do and all that, and especially on voice control, how to lower my voice, etc., etc. And more than that, and one thing he used to say regularly was, Shrikant, if you have taught a subject or if you have spoken to an audience and at the end of the session there are no questions, then you can make two assumptions. Of course, one assumption is that you have completely communicated the topic to their satisfaction. And of course, the second assumption is there. And he used to just smile and a twinkle in his eye, and he would say, of course, you don't have to tell what the second assumption is. But if you have to confuse them so much that they are unable to ask any more questions. So let me, in my favor, presume that it is the first conclusion that I will take. And still, if you don't have any, if you have any questions, feel free. Compounding is fairly simple. In fact, as a professional, once you are employed in a large company, let us say that you are forced, in some circumstances where the offense has been committed and you don't know what to do, and your MD is, sort of very keen on a solution. He's saying, Mr. CFO, please don't, sort of embarrass us. Do something about this. Then you can always go back to him and say, sir, here is an opportunity under the Act. Luckily for us, this is only a fine matter. Let us not go for prosecution. Let us go for compounding. And you can file an application before the regional director and ensure that the matter is compounded, which means the proceedings will be dropped and the directors will be treated as acquitted. The matter will be recorded as acquitted. Convicted means found guilty. Acquitted means found not guilty. Okay. Please don't see English is such a beautiful language. Huh? Not found guilty is different from found not guilty. Okay. Not found guilty means there is some doubt still. Whereas what the English law requires is the person should be found not guilty. Of course, nowhere in the world, even in the US, rarely, we will see a decision says he is innocent. The maximum decision can come is not guilty. That's all. Okay. Acquitted, not guilty. Innocent that means that person's innocence should be proved beyond doubt, not beyond reasonable doubt, beyond doubt. The fact should be so clear that he is innocent. Rarely you will find a court of law saying so-and-so is innocent. What they will advise say is he is not guilty. Okay. So moving on from these uncomfortable topics like, arrest, imprisonment, all that stuff. Let's move on to other topics. But then before we do that, we still have something to discuss. Now, some of you might have been wanting to ask, sir, you said, except offense under section 212.6. Sir, what is the 212.6? You have to tell us. Yes, we will. 212.6 is a topic that you would have studied earlier under the inspection and investigation, where there is an investigation into the affairs of the company by serious fraud investigation office, SFIO. Okay, there they say regarding cognizability of offences, remember, all offences under the Companies Act 2013 except offence under section 212(6). So what does 212(6) say? It says, notwithstanding anything contained in the Code of Criminal Procedure, offence covered under section 447 of this Act shall be cognizable. So 212(6) is referring you to 447. An offence covered under section 447 of this Act shall be cognizable, and no person accused of any offence under those sections shall be released on bail or on his own bond. Do you understand? If it is non-cognizable, he can be released on bail or on his own bond. But if it is cognizable, the person shall not be released. No person shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application. So the public prosecutor will be given an opportunity. Of course, the public prosecutor can stand up in court and say, Your Honor, we are not opposing. He can do that. If you have already spoken to the public prosecutor and told him, Baba, please don't, then he can say, we are not opposing, sir. He is the MD of Magna Limited. So now he won't say that. He will say, he simply stand up and say, Your Honor, the prosecution has no objection, or the public prosecutor's office has no objection. Shut up. The judge will look at him. Then he will say, Chalo, no problem. Since you have no objection, let me go into the matter. Then obviously your advocate, you will hire one of the best advocates in the city of Mumbai or Delhi or Chennai or Kolkata, and they will stand up and argue for 25 minutes, citing Supreme Court decision. This, sir, even in this case, citizens' freedom is very important. He is the MD. If he does not go to office, the entire office will collapse. The entire industry will collapse. All that you will try to give a big story. I mean, that's why the lawyers are there, no, not you and I. We are, after all, mere chartered accountants. We can't do this. The lawyer will stand up and he will argue. And finally, the court judge will ask, so what do you want? Sir, Your Honor, bail. Okay, bail. Over. But that before doing that for a cognizable offense, the public prosecutor should be given a opportunity. Let us say that he does not oppose, no problem. That is the ideal solution. See, you fix it in such a way, your advocate should ensure that the public prosecutor will stand up in court and do nothing. Your company secretary should go and talk to him and plead with him and say, don't do it, sir, please. Okay, chalo, no problem. It's a good case. What you're saying is correct. But where the public prosecutor opposes the application, then the matter becomes an argument, where the public prosecutor will give various reasons why granting bail will prejudice the prosecution. Where, as I told you, one of the important objections would be, he is a very influential person in society. Evidence is being now only collected by the SFIO. See, the SFIO is now only collecting evidence against him. He has committed huge fraud in respect of capital market cases. So he has taken money from the public. Yes, we are still getting evidence. Suppose you let this guy go out on a bail. The first thing he will do when he reaches his office, get down from the Benz car, run up to the 8th floor, call all his employees, threaten them. He will call all the employees and threaten them. And he will say, look here, if you cooperate with the SFIO, we will take action again like that. Of course, relate this to your inspection and investigation topic. There you would have studied temporary protection of employees when they are being threatened like this and all. Whatever it is, he will do all nonsense. He will try to create some fear, or he may try to destroy evidence, etc., etc. Therefore, please don't let him go out of jail. That is what the public prosecutor will say. Your advocate will stand up and argue vehemently, as I told you, citing various constitutional law cases where freedom of the individual, blah, blah, the constitution grants, blah, 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 blah. Whatever is the lawyer supposed to do, he will do. Whoever is the winner, the court will decide. That is the whole point of the court, right? Finally, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. So, by and large, it seems like he is innocent, but we still have to go through the case and he has to prove it. But as of now, I will allow him to go. So, they will give bail. But the court, if it is satisfied, can give bail. Remember, sometimes, that in some websites and in some places, they will put wrongly as non-cognizable offences are bailable. Cognizable offences are non-bailable. Sorry, no. Both the offences are bailable. Except that non-cognizable offences under the Companies Act, other than 447 referred by 212(6), all other offences are straightaway non-cognizable, which means the minute you stand up in court and say bail, they give you bail and go on your own bond. But if it is 212(6) read with 447 we'll see, where it involves fraud, then, sorry, it's not automatic. Public prosecutor has to be given an opportunity. If he makes a compelling case, then the court may deny bail also. But if your advocate makes a compelling case, then he may grant bail. It's the discretion of the court. So it is not correct to say all cognizable offences are non-bailable. No, they are not automatically bailable. Bail is not automatic. That's all we have to understand. Okay. I mean, if this is a little too complicated, please run with me, try to understand it, because I'll make this point. Okay. Where the person is under the age of 16 or is a woman or sick or infirm, he may be released on bail if the special court so decides. So in those cases, some special consideration is given for such people. 16 years means he's a minor. So the parents will be made to take responsibility for him. Of course, even then they have to go to the police station, local police station, on a daily or weekly basis and sign. All that is there. You can't just like that escape. Bail doesn't mean that you can go and do whatever you want. You can go to Maldives and enjoy yourself. No, it means you should stay in the same place. You should report to the jurisdictional police station and sign. So long as the case is pending, you have to do it. Till you are acquitted, you have to do this. Okay. But at least, people who are minors, women, or sick or infirm, they'll be released on bail. Sort of, even though it's cognizable, they will be given that benefit. Right? Again, depends. You see, it's all at the discretion of the court. Okay. So that is 212(6), and we will have to relate it to 447. Okay. So offences covered under section 447 shall be cognizable. 447 is a punishment for offences committed under all these sections. Are you able to understand? You don't have to remember it. Merely for ensuring that these notes are complete, I am giving this to you. What you need to remember is, any offence which is punishable by section 447 is cognizable, and therefore bail cannot be granted unless blah blah. Public prosecutor is given a. I mean, some of these are in the intermediate syllabus. Yeah, most of them are in the intermediate syllabus, if I may say so. 34, 36, that is misstatement in prospectus, civil liability, criminal liability, right? All that. So now, as I keep on saying, all this is distressing for human beings. Going to court, appearing, hiring an advocate, paying him through your nose for doing practically nothing. All this is very tiring. So is there another way out? Yeah. I don't know if I'm sure later on, another learned faculty would take you through what is known as alternative dispute redressal mechanism, especially arbitration and conciliation. Okay. These are called alternate dispute redressal mechanism, where since we already saw that courts are slow, courts create a lot of procedure, and it's very, very distressing to go to court. Okay. Is there another method? They say, yes, why not come for alternate dispute redressal? Later on, you'll be studying arbitration and conciliation in detail. There are actually 4 methods of alternate dispute redressal, ADR, alternate dispute redressal. Where there's a dispute, one method is to go to court and fight it. Where I have a legal case against you, I'm the plaintiff, I go to court. But the law suggests alternates. Instead of going directly to court, go for one of these methods. The first is called negotiation, where simply the 2 parties come and talk to each other and listen, understand, explain, and come to a conclusion. Possibly go for a renovation of the agreement and move on with their life. Best, don't go to court. But next method is mediation, where instead of doing it on your own, you have a person called a mediator, who is an expert and who will sit and he will mediate. Okay. Now, the mediation is a very powerful method of relief. of course, see, all courts, magistrate courts and high courts have a mediation panel associated with them. They are registered under the court. A mediator need not be an advocate, but usually most mediators are members of the bar. Obviously, because they know a lot of procedure relating to how to hear a case. Sometimes they are retired judges or senior advocates, mediators. Of course, chartered accountants can also become mediators. Our institute is really working on making this popular so that a practicing chartered accountant could empanel himself or herself as a mediator with a local high court. You will have to, I think, pass a written exam for that, but that's not a big deal. And then you will be registered as a mediator. Okay, and so already it is there in the Civil Procedure Code. So mediation is already there in the CPC, where you'll be seeing all this when you come to Arbitration and Conciliation Act. So mediation is already there in the CPC, where the court, itself can say, hey, your matter is straightforward, Ishuma. It doesn't need me. Even a mediation can help you. All you want to decide is whether the quality is good or bad and whether the price payable is correct. Only two matters are there. Why don't you go for mediation? We'll put a guy there. Maybe in addition to a judge, a retired judge, I will also put an engineer. It's a chartered engineer. Okay, both of them, let them sit. Or one more, maybe a chartered accountant also I'll put for financial matters. Three of them, let them sit, break their head, and then mediate between you, hear both of you, and finally help you to arrive at a conclusion and a solution. Okay, this is called mediation. This happens in a civil court. Now, this can also be done when there are proceedings before the central government or the tribunal or the appellate tribunal. For example, if the regional director is hearing a matter, or the tribunal or the appellate tribunal. There are many cases where applications are made before these bodies by parties. I'll give a simple example. Oppression and mismanagement, where one group of shareholders in a company is complaining that the company's affairs are being conducted in a manner oppressive. Other group is obviously saying, no, the matter will come up before the tribunal, right? Now the tribunal can look at it and say, hey, look here, I don't see much law here. It's most facts. You are saying he did this, he is saying he did this, they're throwing accusations at each other, and we are wasting the time of this tribunal. Why don't you look at mediation? We have a panel of mediators. Under the section 442, we have set up a panel of mediators consisting of experts having such qualifications. As I told you, a member of chartered accountant, cost accountant, an engineer, of course, a judge, retired judge, or a senior advocate. Whatever. The idea is they bring some expertise with them, which can help you to look at the matter from a different angle. And out of that panel, why don't you take this and proceed? They can say that. So where any proceedings are pending before the central government, in this case, mostly the regional director or the tribunal or the appellate tribunal, then reference may be made to the mediation panel. So reference to mediation may be made at any time during the pendency of proceedings. So the reference can be made either who will refer, the central government or tribunal or appellate tribunal, as the case may be, will refer the matter. How maybe one of the parties can come and make an application, or both can make an application and say, we now feel that there is no need for you to hear this matter. We will go for mediation. Finally, we'll come to you with the mediation agreement. Please convert it into my order and give it to us. Oh, welcome. Please go. So on application by any of the parties, or as we already said, that concerned body, the central government or tribunal or appellate tribunal, suo motu. Suo motu means on its own motion, by its own decision, suo motu. Okay? It may refer for mediation where it deems fit, where it finds that the matter can be easily resolved through mediation. See, judicially directed mediation is what we are talking now. Okay? Where matter becomes a case before a court or tribunal, as the case may be, then either under the CPC or under the section 442 of the Companies Act, the concerned body directs mediation. This is one method of mediation. But believe me, many chartered accountants, practicing chartered accountants, we already do mediation. It's not as if we are not doing mediation, because whenever there's a financial dispute, the first person they come to is the auditor. Especially in the case of family businesses, partnership, etc., where there is a partnership breakup between two partners, they don't rush to court directly. The first thing they do is they fix an appointment with the auditor, and then one by one they come. Sometimes one of the parties will come and start complaining, and he will say, "Sir, the fellow is doing like this, sir. What to do, sir? What to do, sir?" So then the first thing maybe I would do, or any senior chartered accountant do, is, "Boss, you have been talking a lot. I have been hearing you. I'm sure you have a valid point, etc., etc. But should we not hear the other person also? Audi alteram partem. Yes, sir. I will bring him also." So one evening, after, usually these type of discussions, I have it only in the evenings. I make them come at 6 o'clock, finish all my regular work. Then 6 to 8, I order a cup of filter coffees for all of them, and then start. "Okay, now you tell." Then I keep notes. Then I finish that discussion and I say, "Brothers and sisters, whatever may be the fight, first, examine your own conscience. You have been good friends. You have conducted this business well. Don't end on a negative note. If you would like to continue, try to. Otherwise, breaking also, let me do it properly for you." Then they will say, "Yes, sir, you are right. There are many issues." Because by then the emotions will be very high, and we'll de-emotionalize the situation, and then we'll tell them to look at it pragmatically, and then possibly sit with them separately, arrive at what is it that the minimum requirement they have. Mediation is a very, very exciting process. Believe me, at the end of the exercise, there will be definitely a dissolution of the partnership or a retirement, but it will happen upon very smooth terms, which would be agreed to between the two parties, and they will execute it also. We will ensure that they comply with it. Of course, if at any stage mediation breaks down, one of the parties is angry and keeps on shouting, abusing, blah, and he is not cooperating, then we will raise up our hands and say, "Sorry, ma, mediation cannot work here. You go to the advocate." So matter will go to the advocate. One of them will go to the advocate, file the suit, etc. That's all. Thereafter, then again it may come for mediation through the court-directed mediation. So mediation is a very beautiful method of resolving disputes, less costly. The minute you go to court, you have to pay through your nose. Later on, when you come to arbitration and conciliation, please relate to that. It's called alternate dispute redressal. Of course, even mediation carries a fee, because the experts cannot come and sit free. So of course, when I'm doing this type of shall we say, gratuitous mediation for my clients, I generally do not charge. But sometimes, when the number of meetings keeps on increasing, one or both of them come and say, "Srikanth sir, you are spending a lot of time on this matter. Please charge us." So once they say charge, I will charge them a fee. So fee is definitely involved, and other terms and conditions of experts also will be prescribed by the body, the tribunal or whoever it is. The rules, the methodology to be followed by the conciliation and mediation panel is to be prescribed in Rule 11 of the Special Courts Rules, and it has to be complied with. And the mediation panel will dispose of the matter referred to it within a period of 3 months from the date of such reference. Okay, some of you might think all this is fine, but how is it all related to my examination? I'll tell you. Simple multiple choice question. Okay. The mediation and conciliation panel appointed under the Companies Act shall dispose of the matter referred to it within a period of A, 1 year, 12 months, B, 9 months, 3 months, 6 months. You have to choose the right choice. So the matter should be disposed of within 3 months from the date of reference, and it should forward its recommendations to the central government tribunal or appellate tribunal. See, the basic point is an arbitral council can give an award, which is binding. Okay, but mediation cannot result in an award. It can only result in recommendations. Sometimes the mediation could result in an MOU, a memorandum of agreement, or even a mediation agreement. At the end of the exercise, usually when I do mediation, I ensure that at the end of the exercise, what all was spoken, I would have taken notes now. I will prepare an understanding document. It will be cleared by both the parties. Based on the memorandum of understanding, I will prepare a proper mediation agreement, which would be signed and witnessed. And that becomes the guiding factor from now on. So they have to comply with it. So they have no doubts after that. They only have to comply with the mediation agreement. with regard to dissolution or with regard to retirement or whatever the terms, everything will be stated there. What will be the value at which it will be taken over, who will take over which property, everything will be written down so that they should not have any further need to go to court. Okay, so the recommendation of the mediation panel should be like that, and it should be presented to the concerned body, based on which the concerned body will pass an order. Okay, I am not happy with the recommendation of the mediation and conciliation panel. Then the concerned party who is aggrieved, who is not happy, may file objections to the central government or tribunal or appellate tribunal, as the case may be. Finally, the concerned body will hear everything and pass an order. Based on the recommendations, the objections, they will pass an order. So final order will be passed by the concerned body, but the mediation, see, much of the work of the court will be done with mediation. The body will be, so that what they get will be clean. This is what it is, this is the agreement, they have to immediately implement it. So this is as far as mediation and conciliation is concerned. Then we have section 443, which talks about the power of central government to appoint company prosecutors. So just like, in the court, if you want to file a prosecution before the special court, etc., the assistant registrar prosecution cannot stand up and do it. Okay, because he's not an advocate. Only an advocate can stand up in court and argue. A person who is not an advocate cannot even enter the area. He has to simply sit. So the assistant registrar prosecution or the central government, as the case may be, can only brief. So they have to appoint a panel of prosecutors. So they will identify. The central government now has been given the power to appoint generally a person and say he is our standing counsel. He will represent all prosecution matters generally. So the minute there's a prosecution, we will brief him. Or, see, this gentleman would be a practicing advocate. He would not be an employee of the court. He would be a practicing advocate. And one of the jobs he will do is, whenever he receives a prosecution petition from the complaint from the ministry, he will immediately, central government, he will immediately take it to court and file a prosecution. He will represent the central government. The prosecutor, the company prosecutor will represent the central government, the interest of the ministry. So he's also known as a government pleader, like a government pleader. Okay, though a government pleader is slightly different from a public prosecutor, because for offences under the Act, when there is a penal provision, when you go for prosecution, you will involve the company prosecutor, who may be appointed generally. Or if it is a special case like Sahara case and all, there are so many interrelated matters, then you might hire a very senior advocate for that case alone as the government prosecutor, company prosecutor. Okay, or in any case, or for any specified class or cases of any local area. As I told you, Sahara has violated so many laws. So many people have complained. Okay, so a lot of prosecutions have been done. Okay, so they may appoint one man to take up everything. He will prosecute for all those cases. And finally, his goal is to get relief and also to bring justice to the. So these are called company prosecutors. And the central government has the power under 443 to appoint these persons. And they will be similar to the public prosecutors who are appointed under section 24. See, the public prosecutor is an employee of the Ministry of Law and Justice. He is an officer of the court. Of course, every advocate, once he is enrolled in the bar, is an officer of the court. Okay, and he is bound by certain ethics and behavioral code. But public prosecutors are representing the government or the people. The people of this country are represented by the public prosecutors. So when an offense is committed, then the public prosecutor will take it up and prosecute the matter. But for the case of company matters, you will not involve the public prosecutor, but rather you will involve the company prosecutor, who would obviously know the company law in and out. Okay, but be careful. Where there is a cognizable offense, bail can be opposed only by the public prosecutor. Please note here. Here the word is used, not company prosecutor. Here it's called public prosecutor. The public prosecutor only will come and oppose the bail petition. Right? Other than that, taking the case up, filing the case against the person, all that will be done by the company prosecutor who is appointed, who is the normal practicing advocate who do this as part of his practice. He will be representing the central government in this matter, for which he will be paid a fee. So you have in income tax act also. Many advocates are appointed as departmental representatives who would appear on behalf of the income tax department. Okay. Notwithstanding anything contained in the Code of Criminal Procedure, the central government may direct any company prosecutor or authorize any other person either by name or by virtue of his office to present an appeal from an order of acquittal passed by any court other than a high court. And an appeal presented by such prosecutor or other person shall be deemed to have been validly presented to the appellate court. Just think about it. A case is going on. Evidence is presented by the company prosecutor. The court is hearing the matter. On a very, very fine technical issue, they say not guilty. Whereas that fellow is guilty. Fellow is committed the offense. But on some flimsy technical matter, the other advocate has beautifully argued and built up a facade of case laws and said this case law, that case law. Finally, he's got that his client acquitted. Fantastic. Because that is the job of an advocate. But then the fact still remains that as far as the central government is concerned, that person is still guilty. So against an acquittal, can I go on appeal? Yes, you can. There is a power under 444. Merely because he has been acquitted by the lower court, by the special court or by the magistrate court, doesn't mean that he can escape. You can go for an appeal by a lower, against an order by a lower court, acquitting the person. Other than a high court. Against the high court, no. Against the high court, okay, if you want to appeal, you can, but that will come under the CPC itself. Okay, you can go to Supreme Court where it's very restricted. You can't just like that move. It has to be a substantial question of law and all that. But lower court has acquitted the fellow. Now the central government honestly feels this is wrong. So they want the higher court, in this case the appellate court, the higher court, to consider the evidence again and apply its mind and say, no, this is a very flimsy matter. By and large, this fellow has committed the offense. He should be punished. So whatever it is, against an acquittal, an appeal can be presented by the company prosecutor or any other person authorized. Okay. And the central government has been empowered to do this. Right. Sometimes a person may be wrongfully accused. Okay. Without reasonable cause. And the court, sometimes the ministry may also be misguided and they might accuse the person and bring him up before the court and prosecute him and all that. Finally, he has been acquitted. Then he can claim compensation from the concerned parties, the complainant, the ministry, the regional director. Everybody has to pay. The central government has to pay compensation. This is not only under the Companies Act. Anywhere where under criminal law you have falsely accused or without reasonable cause accused a person because of which his name and fame has been destroyed or his time has been wasted, money has been wasted, he is entitled to compensation under Section 250 of the Code of Criminal Procedure. That provision will apply mutatis mutandis, means with such changes as may be applicable to compensation for acquisition without reasonable cause before the special court, right? So this power is retained. So actually we are going through a lot of provisions which are related to judiciary. This particular chapter is the judicial part of the Companies Act. Right? All along you have been seeing the operational parts. This chapter is more about the judicial parts. Right? Now, okay, here I have one question, so let me answer it. By Mr. Sumit Jain. Wow, welcome, sir. Sumit is asking a nice question, whether compounding of offences are automatically or accused. 100% you have to make an application, sir. It is not automatic. See, the person who wants to escape conviction, has to make an application to the concerned body. The regional director or the tribunal will not take so much action. Why should they? What is their problem? It is the concerned party who is accused, who is concerned now. he has to make an application for compounding. Not only under the Companies Act, wherever if there is a prosecution proceedings and the offence is compoundable, then an application has to be preferred for compounding. The format of the application, etc., will be prescribed in the Act itself. You simply have to fill it up, pay the fee, etc., and go to the concerned, That's why I said the offence will be compounded on payment of the. It will not be taken up by the court. So, can a CA be a public prosecutor? Absolutely not, sir. You have to qualify yourself under law. You have to get a degree in law. It should be from a recognized university, and then you have to apply and become a member of the bar council of under some jurisdiction. So either the Madras High Court or the Karnataka High Court. See, or whatever, Kerala High Court. It's a beauty is the Madras High Court is called the Madras High Court. It's not called Tamil Nadu High Court. Whereas the Karnataka, Kerala, or Andhra Pradesh are called respectively. Obviously, because all these were controlled from Madras Presidency. And so one time the Madras High Court was the Presidency High Court. These were all not. So once they became state capitals, the state government name is used. Whereas the Madras High Court alone is called the Madras High Court, not the Tamil Nadu High Court. So CA cannot be a public prosecutor, Mr. Smith. Okay, but that's an interesting question you are asking. Okay, you want to become a public prosecutor? Don't even bother. It's a very low-paid job, loser's job. Seriously, nobody wants to become a public prosecutor. But company prosecutor is different. If you are a good advocate and if you are having a good knowledge of company law, then you can get yourself appointed as a company prosecutor, and it could be that's a lucrative assignment where you will be able to appear regularly on behalf of central government and get some good fees. Public prosecutor is a job, okay? The government of India job where every day you have to go to office like everybody and work, and you have to appear before the court on behalf of the government and bring up these cases. I leave it to you. If you still want to become a public prosecutor, then please, in addition to CA, you are. Many people have done that. Don't think that not public prosecutor. Many chartered accountants have also completed a law degree. I can give you 100 examples of people who are LLB, CA, and also LLB. Okay, have got a BL, not a BL. No, you don't have a BL degree. It's called LLB. So they are a LLB, and you can. But then the next question Sumit should ask me, sir, can I practice as a chartered accountant and as an advocate? No. You can either practice as a chartered accountant or you can become a member of the bar. The minute you become a member of the bar, okay, you cannot practice as a chartered accountant. You have to surrender your certificate of practice. So be clear what you want to do. Right? But many chartered accountants who have become experts in income tax and who are very specialized in appellate matters before the tribunal and then high court, they find that it's better for them to practice as advocates rather than as CA. So though they have a qualification of a chartered accountant, they practice as a advocate. In fact, I still remember in the 90s, one of my good friends, Mr. K. Ramesh, okay, a member of all the three institutes, triplet, CA is and he started practicing as a chartered accountant successfully. And he started a firm, then he handed over his practice to his partner, and then he went on for, at that time, he had to do 3 years law. He did it, I think he did it in Madras. Initially, he did it in Trichy High Court. Then he came back to Chennai. He got transferred to Chennai. He did an evening college. He attended law in evening college. He completed the law degree and he went on to become a very, very senior, very, very popular advocate. And he was an expert in Foreign Exchange Management Act. He is an expert, rather. Sorry, still an expert. Foreign Exchange Management Act. So much so that, he's Mr. K. Ramesh, a member of our institute. But practicing as an advocate, he used to be so much so, he used to be called Fema Ramesh. Such a name, Farah Ramesh, when Farah was there. So he was authority on that subject. And as a lawyer, he used to appear under FEMA before the courts. Economic offenses only, he used to appear. And he had a passion for law. So imagine a guy, three professional qualifications, plus a law degree, and then he moves on to become a practicing advocate. And he was a practicing chartered accountant, went on to become a practicing advocate. I had the good fortune to be a friend or still a friend with these people. So inspirational. When I see people like Ramesh and all, I say, I'm worth nothing. I say, Maximum I could do only ACS and CA and then practicing as a chartered accountant, and quite happy what I'm doing. Though becoming an advocate, actually I was tempted when I saw Ramesh doing it. I thought I would do it. I was about 26 years old at that time. Thought maybe we should try, but then better counsels prevailed, and I thought CA practice is excellent, and I like this rather than getting into law. Okay, maybe somewhere that need to become an advocate. I don't know how, but my son becomes a law advocate, and he practices in the court. So, but vicariously, I suppose I can enjoy this. Good, sir. Moving on. Just give me 1 minute. Sorry for that. Continuing with the subject. We have seen 445. Now we'll go to 446. See, when the court is levying a fine or imposing any fine, what happens with that fine? Who takes it home? Definitely not the judge. Believe me. Okay, it goes to the government bank account, the government treasury account. All the fines that we pay, okay, goes to the government treasury account, and it is used. You know why? All those fines that we pay, or the accused people the convicted people are paying, goes for paying salary to the judges, for maintaining the court buildings, because the judicial system needs to be funded, right? Our tax money is not enough for it. So these fines are also used for that. After all, see, since you have violated the law, the persons who violate the law have to pay for the benefit. So they said fines will be used for that. Of course, there's a clear-cut revenue circulars are there as to how it should be split. What section 446 is saying is, under the Companies Act, where there is any fine being imposed by the court, the entire amount or a part can be applied for payment of the costs of the proceedings. Think about it. Suppose a person is, remember, the central government has to pay the company prosecutor. Now, the company prosecutor doesn't come free. He is a practicing advocate who has to pay a fees for every hearing he'll go. He'll be charging you. Maybe you would have got a tender from about five or six of them. You would have floated a tender and you would have selected L1. But finally, there will be a fee. First appearance, active appearance, 35,000 rupees. Inactive appearance, 10,000 rupees. Something he will charge you. And every time he stands up in court and says, Your Honor, immediately you have to pay him. So all that money, both the central government has to incur and the accused also has to incur. Suppose the accused is acquitted tomorrow, he can say, hey, you made me do all this, give me money. For that, we are giving him compensation, right? We are giving him compensation. In addition to that, any costs incurred by the central government can also be repaid to it out of that fine. Also, suppose an investigation was brought about because of which a serious fraud has been discovered and society has been saved from fraud. Who will give that information? Usually employee. Obviously, the employee who is sitting there, he will become an approver. It's called approver, and he will give some information. Based on that information, we would have discovered a serious fraud and recovered a lot of fraudulently, and because of which, when we see 447, you will know. The penalty could be 5 times, 10 times the amount. So all that money will be collected now. Out of that, a certain amount can be paid as a reward, a monetary reward, say 20% or 10% or 5% as a reward to the person on whose information the proceedings were instituted, right? Of course, while deciding the fine or amount, etc., the special court or the court, as the case may be, should have due regard to the following factors, like, for example, the size of the company, the nature of business carried on by the company, what is the real injury to the public interest, right? This fellow has not conducted AGM. There are 7 members in that company. 4 of them come from the same family. 3 are friends and known people. 7 of them are there. They have not conducted AGM. Correct. It is a crime. I mean, it is an offense. Sorry, not a crime. It is an offense. Okay. What to do, right? Chalo, pay some fine. So while deciding the amount of fine, they should have nature of what is the size of the company, nature of business, injury to the public interest, what is the nature of the default. See, not holding AGM, right? As you know that the magistrate was saying, every day, every corner people are holding meeting. Why this fellow cannot hold meeting? It's not okay. But suppose it is a listed company and they have not held the AGM. Okay, that's serious, yeah, because substantial amount of people are involved here, and you have taken money from the public. You have taken your hat, gone to the public, and taken money from them. Now you are answerable to society. Therefore, the fine should be of definition. But small company, I mean, not small company within definition, a chota company which is not doing very big. Okay, please don't confuse. There is a small company definition. No, not that. This is any company, not much impact on commercial matters. Hey, that fellow has made misguidedly he became a company. Okay, many times when I go when I deliver speeches in down south to entrepreneurs, I even encourage them to corporatize. For example, when a company reaches a certain critical mass, say like if it reaches 500 crore turnover or so, if the entity has not and they are still a partnership firm or a sole proprietary, which happens in many remote parts of India, I strongly advise them to go for a corporate form of organization. But by doing that, I will educate them, or I will see if they are prepared for it. Because sometimes, these guys will misguidedly corporatize themselves, but may not have the knowledge, or they may not even hire a chartered accountant or a company secretary to advise them. And they will simply know unknowingly, right? So you did not really know. Once we'll forgive you. Pay some small fine and go. Next time if you come, that's a different story. Okay. Now, there is a 446B here which says, if a one-person company or a small company, now here we are talking about small company as per the definition. Okay. As per the definition, based on the paid up capital and the turnover, you decide whether it's a small company and 20 crores and 200 crores. And if it is satisfied, then it is a small company. If such a small company or a one-person company fails to comply with provisions, then such company and the officer in default of such company shall be liable to a penalty which shall not be more than 1/2 of the penalty prescribed. Suppose the prescribed penalty is 10,000, OPC and a small company will be paying only half, 5,000. So it's a concession given to OPC and small company automatically. 446A says you have to have consideration for the size, etc. But if it is a small company or a OPC, straight away 446B. If it is 5,000, if 10,000, it automatically becomes 5,000, right? So we've already seen this. So as we said, OPC or small company fails to comply, then 1/2 of the penalty. That's applicable only to these three sections. Only for these three sections, it's 1/2. For other sections, OPC and small company, everything is same. Only for these three sections, okay, the penalty will be 1/2, right? 92 subsection 5, failure to file annual return. 1172, failure to file certain resolutions and agreements. 137.3, failure to file copy of financial statements. All the three are in your intermediate syllabus, unfortunately. But no, I think 137.3 is in your syllabus. No, 137.3 also not in your syllabus. Correct? You begin somewhere in 150 only. Your syllabus begins there. Directors. Okay, good. So, three sections, if you commit any offense, then the penalty is only 1/2. Other sections, full penalty. Where discretionary power is given to the court to decide. There they can decide based on the size, etc. But these three sections, straight away it's 50%. Straight away 50% penalty. Right? Just as a matter of knowledge, I'm covering 447. 447 is a ubiquitous provision where you will find it is constantly coming up for discussion. Basically, this is for fraud. Where there is a fraud, then the 447 prescribes the penalty. Where the fraud value is less than 10 lakh or 1% of turnover, the fine is restricted up to 50 lakhs or 5 years. Now, friends, this or becomes very significant for you with your knowledge. If the fraud is less than 10 lakhs, or 1% of the turnover of the company, whichever is less, then fine is 50 lakhs or imprisonment, which means what? This part can be compounded. So even if there is a fraud, you can go and get yourself compounded. You can go to the tribunal, because if it's more than 25 lakhs and request compounding, application should be made. But where it's more than 10 lakhs or 1%, whichever is less, then the amount of fraud, the minimum penalty is the amount of fraud. Maximum is 3 times the amount of fraud. Okay. And now this and becomes very significant, right? You cannot compound it. This offense cannot be compounded. Minimum 6 months imprisonment, maximum 10 years. At best, what you can do is you can plead for minimum. You say, please, let me go to jail for 6 months. Like that, you can say, that's all. Okay. Now, where it involves public interest, where substantial amount of public are being affected by the actions, like in the case of Sahara, Satyam and all that, the fine is the same, amount of fraud, 3 times the amount of fraud. But the minimum imprisonment is not 6 months, it is 3 years. Minimum 3 years he has to go to jail, where public interest means where you have gone to the public and collected money, and because of which the public are going to be affected by you, then minimum 3 years imprisonment. Of course, the section defines fraud, okay, and also talks about wrongful gain and wrongful loss. Anything that you make unlawfully, which you gain unlawfully, or which some other person is losing unlawfully, that is a wrongful gain or wrongful loss. So, coming quickly to adjudication, we already discussed adjudication in detail. Okay, means there is an officer of the central government attached to the regional director whose job is to prosecute. So, before going for adjudication, the central government itself, being an instrumentality of the state, should state the reasons for adjudication. Also, they should give an opportunity to the other party, to the concerned party, of presenting a case why prosecution should not be taken up. So, which is done through a show cause notice, an SCN. So, in fact, this is the first ever intimation that action is going to be taken by the central government. And so, when the SCN is received, you have to be very careful. You have to appear in person before the adjudicating officer, or if it is in electronic mode, you have to give a detailed explanation showing that you have complied with it now and that you will not do it anymore, and requesting them to drop. For all you know, they may drop the penalty proceedings then and there. Many cases, you know what these fellows will do? They will not do anything. They'll keep quiet, throw the paper. Then later on, he'll send another notice where he will say, I will levy the penalty if I don't hear from you within 7 days. Nothing happens. Or then they will rush and try to, then by then the adjudicating officer is very angry with them. He will initiate proceedings. He will initiate. Okay. Now, in case you are not happy with the adjudication, you can always go to the regional director. And the regional director can adjudicate again. The regional director will again decide. But finally, if the regional director also is not happy, the proceeding will go on and the prosecution will happen. Okay. So they have built a very elaborate system within the framework by which opportunity is given to you, SCN is sent, you have to reply, then the adjudication order is passed, then within 60 days you can go and appeal to the regional director. Okay. The regional director will again hear you, and based on the regional director's decision, you can still be, he can say, chalo, escape and go. Or if he is also not satisfied, the prosecution order will be final, and then you have to appear before court. Of course, at all these stages, at any of these stages, SCN level, reply level, don't go and appeal to the regional director. Rather, if you are sure that you have committed the offense and you are going to be punished, go for compounding to the same regional director or tribunal and ask him to hold the proceeding in abeyance till the compounding matter is decided. This is a great opportunity when you should go for compounding. Okay, where somebody is doing a repeated offense, again he is coming out with the same offense within a period of 3 years, then the penalty will be an amount equal to twice the amount of penalty provided. Okay, so if the penalty prescribed is 100, now if you have second offense, then within 3 years for the same section, then it is double. Okay. Now we move on to NCLT and NCLAT, National Company Law Tribunal, and National Company Law Appellate Tribunal. Friends, all along we have seen courts. They are part of the judicial system. Now for the first time, we are seeing a quasi-judicial body. See, a quasi-judicial body is set up under a specific law, like the Competition Act has Competition Commission, it's a quasi-judicial body. The SEBI Act has Securities Appellate Tribunal, quasi-judicial body. Foreign Exchange Management Act has Foreign Exchange Appellate Tribunal, quasi-judicial body. So these are all set up under specific laws within the framework of that law for hearing disputes. These bodies are not courts. They are not court within the meaning of CPC, but they have the same powers as a court. They are like a court, but not a court. They are called quasi-judicial bodies, and NCLT and NCLAT have been constituted to provide a single window for settlement of all disputes relating to companies. So the constitution of the NCLAT and NCLT and NCLAT is given. There is a chairperson, then you have a judicial member who would be a lawyer, an advocate, a judge, or other members are there, whether judicial or technical. So, for example, a chartered accountant with sufficient experience and knowledge will become a technical member, or an engineer could become a technical member. Because here, the NCLAT doesn't only hear legal matters, factual issues also will come up. So usually chartered accountants, company secretaries also will be hired as technical members, right? Then of course you have the president of the tribunal and you have what is known as a technical member. So you have judicial member, you have a technical member, and you have a member who is judicial or technical, okay? He's called a member, right? Now, there is a beautiful system of appeal built within the law. See, for example, you make an application for operation and mismanagement. The National Company Law Tribunal hears the matter, the NCLT, the tribunal hears the matter, finally passes an order. You are an aggrieved party, you are not happy with the order. Then you can file an appeal within 45 days against the order, 45 days from the date on which the order of the tribunal is made available. You have to make it within 45 days. Suppose you have delayed, maybe pandemic, you are suffering from corona, whatever, then condonation of delay is possible for filing beyond 45 days, but within a further period of 45 days, provided you show sufficient cause. You go on appeal against the NCLT to the National Company Law Tribunal. Now, the National Company Law Tribunal is almost at the same level as the High Court. Okay. Now, suppose the NCLT has passed an order wherein both the parties have consented, wherein they have very clearly given a written document saying, I consent to the decision. After having consented, once you receive a consent order, no appeal is possible against that. But if you have protested, see, in the final hearing, in the tribunal, we will protest and say, we are not satisfied. It will record it. So the tribunal will record it. Then we will go, we may not record it, but we will protest. And then we will go to appeal within 45 days. Okay, you go to the NCLAT. The NCLAT hears the case. And finally, they also pass an order against you. You are not happy. Chalo, no problem. You can go on appeal to the Supreme Court. Please note, appeal from the NCLAT lies with the Supreme Court, not with the High Court. High Court is gone now. Straight away, you go to Supreme Court. Okay, the appeal should be filed within 60 days from the date of order. Of course, a further period of 60 days, you can go with sufficient cause. Now, appeal to Supreme Court cannot be on facts. Any factual issue, whether this happened or not, whether that happened or not, is a question of fact. Supreme Court cannot go into it. Supreme Court will not examine evidence. No. If you want examination of evidence, etc., oral evidence, documentary, whatever you want, all that should be over within NCLAT. All that should be documented by the NCLAT. That's why, the NCLAT's order, you should ensure that everything is documented. So that when it goes to the Supreme Court, you are going on a pure question of law. Whether this section is applicable or not. Whether this section includes me or not. Pure question of law only can go to Supreme Court. You cannot appeal on a question of fact to the Supreme Court. Right? As I already mentioned, both NCLT and NCLAT are judicial bodies, not they are quasi-judicial bodies. They are not bound by the CPC. They can have their own procedure, but should be based on natural justice. Means a reasonable opportunity should be given to the other party. Okay. But certain matters like examination of persons on oath, discovery and production of documents, receiving evidence on affidavit, okay, public requisitioning a public record, issuing commissions for examination of witnesses, dismissing representation for default, or deciding a matter ex parte, setting aside an order or dismissal, all this, they have the same power as a court under the Civil Procedure Code. For these specific issues alone, certain powers of the civil court are vested with the NCLT and NCLAT. Once the NCLT or NCLAT passes an order, it is executed as a decree. Remember, court passes an order, it is executed as a decree. So the same way NCLT and NCLAT have the power as if it were a decree made by a court in a suit. Okay, means attachment, etc. can be done, recovery can be done, all that can be done. Okay. Of course, the tribunal does not have the mechanism to execute. Therefore, the NCLT and NCLAT will send the order for execution to the court, where the court has its own mechanism for execution. Okay, they have the officers of the court who will go and, if there is an attachment, the officer of the court will come, he will conduct an auction and sell the property and all that. That power will now come in. And the NCLT will refer it to the jurisdictional high court. Okay. So final bottom line, you should understand NCLT and NCLAT are like courts but not civil courts. They are called quasi-judicial bodies. All matters before them are deemed to be judicial proceedings under the Indian Penal Code. They are deemed to be civil courts. Please understand, quasi-judicial bodies are deemed to be civil courts, whereas court is a court under the CPC, right? So they have the same powers and authority vested in the High Court with respect to reference to the High Court, etc., reference to the Advocate General, all that. As if they are High Court, they can do that. And when there is a contempt of court, see, suppose the court summons, the tribunal summons you, you don't appear, or you appear but you give all sorts of wrong statements and you violate the decorum of the tribunal, then contempt proceeding can be taken against you in the same manner as if the tribunal is a High Court. High Court can recognize contempt of itself. Supreme Court. So when contempt, the minute it's recognized, 2 years imprisonment straight away. You can't simply stand up before court and make all sorts of statements. So contempt of court. And even if you talk out of turn, it's a contempt. So such power is now available with the NCLT and NCLAT. No civil court can entertain a suit where the matter is pending, where the matter is to be heard by the tribunal. There cannot be any overlapping magisterium. Okay, the magisterium cannot overlap. The power of this tribunal is supreme. If it is a company law matter under that section, merger and amalgamation, only NCLT has the power to hear. You can't go to court because court does not have the power. Okay, so you can't simply run to the court and get a stay, injunction and all. If you go to the court, they'll simply say, look here, matter is pending before tribunal. Now go there, ask him, let him give. Unless there's one small loophole. You are saying that the quasi-judicial body is acting beyond its own powers. It's exceeding its own powers. Then and only then can you go to the High Court on a writ or the Supreme Court on a writ of quo warranto. You can ask them to ask this by what power have you got? But that's a rare case. You should show that the tribunal is. See, you will notice now every section in the Companies Act lays down powers of the tribunal. So, if you remember, even for amalgamation, the powers of the tribunal are clearly laid down. If only within that framework it can operate. Suppose it's going beyond that framework, then one loophole is there. You can go on a writ jurisdiction to the High Court or Supreme Court, as the case may be, and because if it's NCLAT, you'll go to Supreme Court, and you will then get the order of the jurisdictional High Court and or tribunal or Supreme Court for quo warranto, by which they'll say, don't do this. It is beyond your power. You can't do this. Like that. Of course, suppose there is any disqualification in the appointment or there is a vacancy or defect in the constitution of the tribunal. With such a defect, if a bench is being formed and a decision has been given, that decision will not be affected. The proceeding will not be affected by the defect in the constitution of the tribunal. So one of the members has been wrongly appointed, but that member sat and the proceeding happened. So no problem. That will not affect the validity of the order. This, as you know, this is called a Ganga clause. Okay, the Ganga clause will cleanse. It will make the whole thing clean. Okay, the Ganga makes you clean. Like that, this clause will make clean. Even if there is a defect, this particular section 431 makes it clean. That's why it's called Ganga clause. So we've come to some sort of an end of this tedious session. And anyway, so agreed by the order of NCLT, passed without the consent of the parties, Madruk Limited decided to file an appeal before NCLT. Meanwhile, the employees and officers of the company went on a strike, demanding higher pay and allowances. And as a result, the operational management of activities were affected. Strike was called off on 15/6/2018. So they want to go on appeal against the NCLT's order. But unfortunately, the office was not functioning from 10/5 to 15/6. So from 5/5, they have to file an appeal within 60 days. But from 10/5, the office was closed. Thereafter, the appeal was filed on 25/6. Okay, which if you really look at it, they should have, the appeal is beyond the due date. Therefore, it should be filed within 45 days, I'm sorry. So it is filed beyond that. Okay, therefore, whether it is valid. Okay. So the question is, the appeal is admissible provided you file for condonation and give sufficient costs. A single judicial member of NCLT started the hearing. Whether is the appeal transferable to a bench consisting of 2 members? Yeah, a single member, if he wants, he can then transfer it to a bench consisting of 2 members. Not a problem. Wonderful. So with this, we come to an end of our lecture on special courts and NCLT, etc. I thank you for your patient hearing and look forward to interacting with you in future classes. Have a great day. Bye.